Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican por his verbos Latinos. I didn't ask you to interrupt.
Is that correct?
Literally not true. Oh, for Trump's sake.
All right. Oops, where'd I go? There I am. Welcome back to the Court of Public Opinion. I am the Recovery Addict. It's been a while. How y'all doing? Hope your hump day is going well. We do have Zimmy, my friend, you're first in chat today. The seats are broken. Give us a minute. We'll get the seats fixed. That's one of the problems of stopping and starting the stream. It's just reconnecting. Zimmy, first in chat. This is not your first offense. I mean, I was just checking your record. You have, in fact, won before. It's been a while. But having won before, you know what comes now. We are, in fact, punishing you for your promptness. We're sentencing you to internet ownership for the rest of the day. Everything IP-related worldwide. Your responsibility. Give me a minute, Zimmy. Well, I take care of the chairs just this one time, and then you fix everything else after. Does that work? Give me a second. Shutting down Lumia Stream and pulling it back up. You have a record? Yeah, we have a record. Well, if you've won, you have a record. Okay, give me a second. Let's see. Overlays. Boom. YouTube chat bot. We're all set. We're good to go. Okay. We're back. Zimmy, good luck and good riddance. I went to the portal world and you made it here. I appreciate those of you who just landed. If you do, click the like button right when you get here. That's the easiest time to do that. That way it saves you having to do chores at the end of the day. The chore being clicking the like. It's not a hard chore, really. I mean, as far as being assigned tasks, it's probably one of the easiest ones you've ever been assigned. But all you have to do is click the like button right as we start, and then you're good to go. You're good to go. And you can rest easy the rest of the day unless you're Zimmy, and he has a lot of work to do. So commands aren't working. Give them a second. They are catching up, JPC. It's just going to take just a moment. But there we go. Seats are working now. All right. The like button is free today. Try it out. Alicia says, cleaning my horse stall. See, that's harder. That's harder than clicking the like button. But it's all good. And first in gifts. Ooh. Did I see it? Let's see if we can find this. Tumwater Troy gifted a membership first thing on the live stream.
You don't put a diplomatic plate on a hoopty.
You don't put a diplomatic plate on a hoopty. That's correct, Judge. See, I made that this morning. Judge Simpson giving us some great advice. Troy, thank you very much for your gift. That is super generous of you. We love Tumwater, and we often go up to Thurston County, Washington, at least virtually. Let's see. What does it mean when chat isn't on the screen? Basically, if I'm clicking on things on my screen, but you only see this, so I can click on all the things I want over here, but you're not seeing it unless I click there. So when chat is on the screen, it's like it fixes it. I can actually set that so the mods can fix it, but I just have never gotten around to doing that. Fun fact: almost everything I do with this device, which powers the entire live stream. I mean, even starting and stopping the show, I could give you guys access to, so you could literally manipulate my entire channel, and for good reason I don't. Is this portal success? It is probably one of the best portals we've ever done. So, all right, so we're in a sort of a holding pattern for just a few minutes, probably about 10-15 minutes. While we wait for the case to begin, which was delayed. Have you seen EDB's new streaming software? No. Laura, what does she have? I assume by new streaming software you're talking about like OBS? What is she? Is she a StreamYard? OBS? Do spill the beans. I love to see behind the scenes. That's why I show you this one. I love it. You're kidding me. Where do I sign up? I'm Googling this. AI can't help at all. Did she just do it? Let's check her website, see if she has it up there. I've heard she has, I think she has an app. Is that what you're talking about? I need to know more. She launched it a couple days ago. That is major league. That's cool. That is awesome. I'm curious. I've got to watch some of this. She's done some test streams and she talks about it. I'm wondering if she went with like 2110, compression or NDI or what how broad the software is. If it's just a replacement for StreamYard, or if it's something more for the collection and distribution of video from source as well. That's really cool. If you have any of her streams in the last 2 days, you'll see it. Super cool looking. Say no more. What are you guys doing for the next few minutes? Boom, boom. She's gonna be live here in 10 minutes, but let me go back a little bit and watch what she's got. I'm going to have to listen to her, which I can't do on the air right now. I know she's been most interested in some techie stuff. Hey, how's it going? No, I'm live. They're telling me that EDB wrote some software for broadcasting that she uses. I'm not sure if she's distributing or selling it or testing it or what, but it's cool. It does look super crisp. I do see still 1080p is the resolution. Okay. I'm curious. I'll have to do some homework here. All right. Sorry, I did get a little distracted there. Officially, it's 10 minutes. I realize it's completely changed up the audio issues. Okay, so Emily, Rob, Ian, Peter, I believe all of them at one point have used StreamYard and have struggled with the audio. And StreamYard is absolutely terrible for audio. I pay them $98 a month for the convenience of making it easy for a guest to join. So we do that for our podcast. That's pretty much all I use StreamYard for, because it is almost impossible to really manipulate and fix sound problems through StreamYard. So I cannot wait for the day that I get to stop paying StreamYard for their service, if there's a better one out there. If Emily's selling one, I just might sign up. Yeah, I've heard that she's looking at cameras and courtrooms. We're on the same page that way. I'm doing the same thing. That's awesome. I'm so excited for her. This is a huge thing. Emily has really has pushed LawTube to incredible heights as not just a pillar of LawTube through legal knowledge and an amazing delivery style and commentary, but loving the tech side of it as well is just awesome. All right. StreamYard used to be much better. Let's see. Sound is out of this world. I love it. I love it. All right. Especially now that most people, most creators have access to extremely high-speed internet. We're talking fiber. You know, I've got 2 gig symmetrical internet, up and down. It just makes possibilities just huge. And let me tell you, in a couple of years, we're not there yet. We're getting closest to this in sporting events. In a couple of years, we'll get to the point where you'll be able to watch, possibly on YouTube, possibly on another platform, watch court the way you want to. So if you want to see a creator on screen, you can choose to see him on the screen or not on screen, or turn their audio on or off. You can choose that. If you want to see a certain camera angle, you would be able to select and say, I want to watch this from this camera angle, or I'd like to watch this array of cameras in this setup. That's where it's going, and we're not quite there yet, but very, very soon. Walker, thanks for the kind words. I've always thought the internet is big enough for all of us, and my goodness, where would I be without great legal minds of LawTube? Me being LawTube adjacent, knowing my place. I'm not a lawyer. I have some experience having watched trials, but I benefit so much from great legal minds and different perspectives that are shared that way. If we fight against each other, it just tears everything down. What do they say? A rising tide lifts all boats, right? It's better to be friends than not. I have 2 internet services. I'll see your 2 and raise you 2. I have 4. 4 is what I like to keep, just in case. Denisha, I understand that a little bit. Some people have been burned a lot of times, especially it's really easy for a smaller creator to get really frustrated. Say if somebody came into their chat and said, "Oh my goodness, this person, XYZ has this exclusive right now live," and for that small creator who's they've worked up to a certain level of viewers and suddenly having just plummet, it's gut-wrenching as viewers just disappear. And I can see that. It's like they're trying so hard, and then somebody comes in and mentions something and everyone's like, squirrel, and they leave. I respect that in other channels. I run things a little bit differently here. I don't say that they're wrong. I think it's okay and perfectly fine. I respect that on other channels for that. But at the same time, I have a perspective where it's my goal to bring you court in the most in the best way I possibly can. The way that I would want to watch court, as far as the best audio, the best video, the most respectful environment. And I say, let me do my thing, and everyone else can do their thing. And if they're the right place for you, that's great. And I'm happy you found somebody to watch court with that just fits your style, whether it's the level of commentary, level of snark, the level of spice, you name it. I love that there are options out there that you can choose. I'm going to do my thing, and it will fit some people, and that's what I can be consistent and offer. And I think over time it will grow organically, and everyone wins. All right. I was scolded once on 2 different channels at the same time. Yeah. I do have some rules that I enforce that other channels don't, and I'm a little weird that way. We have probably one of the tightest ban lists on words that's out there. I'm very aware that there are a lot of people who, even though this is a true crime channel and it's a lot of the content is very much, adult in nature, where we're talking about crimes, that there are a lot of people who use this channel and the court cases we follow to teach kids and students and, people who are novices to true crime about true crime. And I try to keep it family friendly and, as far as murder can be family friendly for that reason. So appreciate that. Is Brandy Churchwell no longer covering trials? No, she's live right now. She's on a different channel. And I think she's actually covering Donna Adelson right now. I think she was live this morning. I get mentioned on Lawn Lumber. Yes, usually the bug gets mentioned. Rob is amazing. Ian's amazing. Good friends. I just have nothing but respect for what they do. All right. Anyway, any other questions while we wait for court to start, YouTube related or otherwise? I will say that I truly have a love for technology. Like if you've watched Napoleon Dynamite, in that movie, Kip, the little brother, the nerdy brother, he's like, I love technology, and he's singing. That's me, right? I'm that guy. I love it, and I love when technology can solve a problem for somebody in a good way, not like take somebody's job. I'm not like trying to bring robots in to replace, McDonald's workers, but that's going to happen by itself. But if somebody's like, hey, I've got this message, I've got this, I feel like I'm driven to share an idea or a message with an audience, and I don't know how to get it to them. I don't know how to do the nuts and bolts that will take my message from my mouth in my studio to YouTube. I love to be able to just talk to them and say, hey, let me help you out. Your message might not be the one I want shared. That's fine, but let me bring it out there. I think more voices makes it makes for a better conversation overall, and it means that if we listen to a lot of different voices, we'll probably make a better decision personally about where we stand on different things. So I have advised many people about YouTube channels, even competitors on YouTube channels. I love it. I love that we can compete. So how do you think Peter Tragos' trial is going? I think he's winning. I think they're winning. Do you have iOS 26 on beta on your phone? I have not done the beta yet. I have some software that I'm testing for cameras for this setup that's not friendly to the beta. So until the software updates, I usually don't update. Let's see. I follow a YouTuber who has 8 channels about 8 different topics because he loves creating so much. All right, I only have 2 channels. Well, I've got like 4, but 2 that are publicly known that I actually post to. Where is Kathy from Gossip Rumor in Innuendo? She's usually in the morning. She's a morning person, if you haven't noticed. Yes, if you've noticed that words get zapped automatically, that's not the mods doing it. If you're trying to type something and you're getting frustrated, like every time I type, it just doesn't show up on screen, you're using a word that for one reason or another was included in our ban list. And the ban list is dynamic. It changes over time. I will not publish it. I've shared it with the mods one time. But Crime Junkie Jury is where Brandy's at, right here. Crime Junkie Jury. And she's doing a phenomenal job. I think she might still do some things on her channel. But anyway, I forgot what I was saying. Anyway, so I can't be everyone's tech support, right? My mom, for example, if there's a problem with her computer, I helped her buy a computer from Costco years ago before I moved to North Carolina. If there's something wrong, I get a phone call. I can't do that for everybody. But if you have an issue with YouTube, or you have a question, or if you're working on a setup for your own channel, and you're like, I'm trying to figure out how to do this. How do you make the words on the screen, or how do you adjust? How do you make 3 people on the screen at once? I'm happy to help. I honestly am. So if you see a channel that's struggling and have some questions, I know somebody reached out to me the other day, said there's a new channel out there. She's struggling with tech. Can I recommend you? I said, sure. And I don't charge for that. So I figure I learned from some great people who spend a lot of time with, a lot of patience explaining something very slowly and with a crayon for me to learn this. So the least I could do is pass it on. All right, Princess Buttercup says, I love being here. Ruff, you're the best. I had to borrow my mom's credit card. Yep. Princess Buttercup, one day you're going to get in trouble for that. Thank you, Rebecca. If you start a class on it, sign me up. I need to learn lots. I've thought about doing a class on live streaming. But I know I'm not the best teacher. That's not my strong suit. I might be the most excited about teaching, but I'm not the best teacher. Why isn't YouTube giving me memberships? It's been 2 years since I've seen anything. Wacky Wheelers, you might want to check and see if you can turn on the gifted membership setting on your channel. And I say if, because some channels are not able to receive memberships. Some channels are set up as a branded account. And I don't understand the minutia about that, but there are different settings for an account, and some just cannot receive gifted memberships because YouTube will not allow it. It might be geographically limited, depending on if you're outside of the country. I don't know if that's the reason, but there could be a very subtle reason. If you can't turn on the settings, that would be an indication. Let's see. Have you ever taken a video on a CD with terrible audio and been able to fix it? My wedding video has terrible audio and I paid so much for it. Shaylin, it is easier to take noise out of an audio recording than to bring... like if you have a duck quacking over here next to the microphone and you have a motor running over on the other side of the microphone, the motor's running and the duck's quacking. I can do this 2 times. It's easier to take the motor out than to make the duck louder, right? If that helps. It's easier to take annoying sounds out. If the microphone itself was just bad placement and just didn't get any audio, if you're cranking the volume, you're just making all the noise louder as well. So it depends. I've had I think Ian sent me some video. It was even wedding related that we did a little work on that. I couldn't do it a lot too, but I could fix it a little bit. All right, where are we? To unbrand your YouTube account, you have to go to the Google account you have associated with YouTube on the account and look for the settings there on Google. And I don't know what unbranding your account might do. If there's anything else going on with your account that you might need to... Ooh, spicy, loud in court. Oops, let's fix that. Our bottom window should be... Holy cow, that's loud. Rest in peace, ears. Do you still give away memberships during the podcast? I do, the first podcast of each month. So it's going to be, let's see, the 31st is a Sunday, right?
Yeah.
The 5th?
I don't.
But not you.
I think I'm laying low today. Laying low.
I rescued dogs 30 months. Oh, gee, just 6 more months till a blue courthouse. Thanks for all you do to make this great place.
I think either Sprinkle or Mike. Either Sprinkle or Mike.
This is just a hot mic right now.
Oh, yeah, it's shooting in here. Yeah, there's small thing. You said that for yes.
Okay, let's turn that off. Well, some of the things I do on court to improve the audio is ding dong. Let's see, turn this down to that, to there. I run filters. So basically, if you could, have you ever seen one of those old graphic equalizers where you have all the green and black, green and red lights that bounce to the music?
I know. That's one of your names.
I find problematic frequencies and tune them out.
You gotta shake your leg like it yourself down there. Yeah. Yeah, he said he'd take. I think he said he'd take one. Do we have anything about him? Was he one of the good jailers?
Okay. I'm going to turn their mics off for a bit. It's not juicy. They're, let me say this. I think the next piece of hardware I get is actually an upgrade to my, this audio board that plays all my sound effects, because the new version, which actually came out years ago, I just haven't upgraded. I just kept the original because it works fine. The new version allows other people with the same soundboard to directly connect. So we can have audio like directly connected with crystal clear. As good as this audio is here, we get their voice just as good, without going through the YouTube compression or StreamYard compression or Zoom or a telephone. It's amazing, device to device connection. So that's gonna be I think the next piece. Getting the mic and the mic audio and my game audio right is what I struggle with most when I stream. Cody, that's a challenge. It's a challenge. You almost have to listen to it or have someone else listen to it, because it's easy for me when I was playing I want to have the game audio turned up so I can hear every sound that might give me an advantage in the game or something. And viewers might not like that. They might not like that level of noise. But my best advice, which I'm still learning even today, watch for feedback, like where they say, "Why is RA so quiet?" Well, let me boost my mic a little bit. Is that a little better for you? I can do that. What are we watching now? We're back in court with the trial on day 5, the serial killer's daughter, Georgia versus Christopher Wolfenbarger. This is day 5, nearing the end of the state's case. So this is they've taken half a day off. The jury's just barely arrived, I think, in the court. I think at 11:30 was when they were supposed to be here. Well, it's now 12:30, so hopefully they'll begin here. Marmar says, "I wasn't 100% it was you that Ian sent my video to. Thank you for helping me as much as you could. I really appreciate it." Marmar, I didn't know it was you. He sent me a video and I did what I could, but it was a tough one to improve. But hopefully it helped a little bit. Corey, which frequency bands do you bump on your voice, accentuate its natural butteriness? Corey, that I use the Rodecaster, which is the audio board. This one I have here on my desk. Let me show. It's this one right down here, so let me get rid of your words. This whole device, it does it. It has some built-in settings that you can turn on that, where did I just go? Oh, I went in the top corner. It has some settings you can turn on that basically make your Rodecaster equivalent to a radio station broadcast setup. And the particular ones that work for me with my voice is a non-flattering little setting called Big Bottom. And Big Bottom gives it that oomph on the lower end. I was blessed with good pipes as well. Those are just genetic, so thank my mom and dad for that. But the combination works. I've found that it's not very good for me to have a noise filter on. As a matter of fact, I can, if you want to listen really quickly, I can turn a noise filter on and tell you, and you can hear the difference. Give me just 1 second. By noise filter, I mean a noise gate. Audio. If I can find the setting. Which I can't. Here's a noise gate. Ready? So this is normally how microphone noise is picked up. You can hear as I start talking, it's very quiet. And then I turn the gate on. And as I start talking, it waits until the sound gets loud enough. And if I'm too quiet, you don't hear anything at all. The noise gate basically says, we're just going to assume there's background noise, which there is. You can hear some. If I cranked the audio, you could hear I've got a little fan blowing. Sometimes I've got a heater vent that turns on. If a PC, the fans get too loud, or you might hear that in background. Noise gate will get rid of that, and it makes it silent in the background like this. But it also cuts out those quiet, this right here. It would be cut out, and it makes it sound a little choppy. So for me, I turn that off. Is there a compressor? Yes, I turn on an oral exciter, big bottom. I turn on a compressor, a de-esser, and a high-pass filter for all mine. And the settings, I mean, there's pages of settings for each one to go into, but yes. I will say that a lot of creators who use StreamYard, StreamYard likes to have a noise gate. If you're using OBS and things like that, a lot of that software is very processor intensive. So your PC, your fan is just going to spin up to keep the thing cool, because it takes a lot of CPU power or GPU power to process it, and so the fans get loud, and you want to keep it out of the stream. So Big Bottom is my rapper name. Sounds good. All right. Lots of nerdy stuff. Corey, glad to help. Let me know if there's anything else I can do. I will say, if you're gaming, a Rode soundboard, even some of the entry-level ones have some really great features that let you manage your audio for your mic and the game together. And I would recommend doing that. If you're doing it in OBS, you're sort of separately managing the audio, but having them in one soundboard where you can really control and see on the level meters where everything's pegging. With broadcast level meters, it's really beneficial. I love doing this. I love court, but I love technology. Have you ever been to Palouse Falls? I have not. Where's that at, PNW? Anyone ever go salmon fishing and have to lie about what lure used and where and how deep you're catching the big kings? Lie as in, no, I was just using a worm. Instead, you've got like a super secret lure. Oh, I've got a spam call. Perfect timing. Hang on. Hello?
Hello?
Hello? Are you there?
Hi, sir. Yes, sir. Can you hear me?
Yeah.
Sir, how are you?
I'm doing okay.
Sounds good, sir. Okay, God bless you. Sir, my name is Chris Montino, and I'm calling from Marketplace Enrollment Center. The reason of my call is that, sir, a special enrollment period is recently approved in your area, and there is a lot of benefit approved in your state. So just qualification purpose, how old are you?
I'm having a hard time hearing you. Can you say that again? Oh, man. Something was just approved in my area. He was difficult to hear, but maybe next time. I always look confused. That was not the typical vacation timeshare thing. So I told him his audio was bad and he hung up. It would be better if I said, I'm a little hard of hearing. Can you speak up? That would have been better. We would intentionally interrupt the mic on the radio so people would only hear green about feet deep miles from the shoreline. That's terrible. I was hoping that would be our...
Georgia versus Christopher Wolfenbarger, case number 24SC004. 201. I'll note for the record that Mr. Wolfenbarger is present here in the courtroom along with his counsel, and that counsel for the state is also present. Mr. Samuel.
Don't look, she's getting dressed.
Well, left court yesterday. I think the prosecutors are still in here. I was walking past, towards the elevator, and one of the jurors was in the sitting area.
Yes, sir.
And he looked like he was, like really, really ill. He was just kind of hunched over, and I have no medical training. Plus, I was debating my role as a good Samaritan, and my job as a lawyer. Fortunately, I saw there was a deputy at the end of the hall, and I went to the deputy and I said, "Someone's got to do. I can't talk to this person." So the deputy went back and talked with him. I was not within hearing distance and stayed out of sight. I gather he was in a great deal of pain from a back injury. I was taking medication. I'm not quite sure what happened after that. I mean, the deputy eventually left, and I didn't. There was nothing
we have an echo.
I wasn't going to sit there with the juror, obviously. I just bring it to your attention that the juror was apparently in so much pain he was taking medication. That concerns me if he's sitting here in the courtroom.
Well, thank you. Do you know which juror it was by number?
Certainly not by number. It was a black man, not the one who does dialysis.
So not 43.
And not the taller man who, I'm sorry, I don't.
Okay. I mean, the main reason I ask is that I'm surprised that you would have such an encounter and that juror or other jurors would not have communicated to my staff, "Hey, I'm having an issue," and I've not heard any such communication from that juror. So if they are struggling with that, it's unfortunate, but it seems as if they don't feel the need to bring it to my attention.
It's not that we don't believe you, sir.
For me to bring it to your attention, but
I understand.
I remember, obviously I see the jury. I've never seen him in the jury box appear under any distress. So.
Okay. Well, what I'll do for now, rather than, formally inquire or put anybody on the spot, is just, if it's okay with y'all, is just have Miss Johnson check in. She's my JA who takes care of the jurors, and make sure everybody's comfortable. And if you're not comfortable or you're having issues paying attention, you need to let me know so I can bring it to the judge's attention and let you know if I get any report from that. Okay.
I'll just make a mental note of where he's sitting.
And then maybe you can tell me, we can identify him further so we'll at least know which juror it is. Okay.
I think you're right. I think because Mr. McDermott brought that to my attention. Mm-hmm. And as I was going out of the courtroom, I saw that juror. I believe it's a juror who may work for Delta, if I'm not mistaken, just shorter black man. I think yesterday he was sitting in the second
or third from the end.
On the back row. I think he had on green yesterday. And I saw him leaving as I was going towards the right, towards the restroom. It looked like he was getting up from that area and leaving the courthouse.
Hang on just 1 second.
He did mention back work on disability.
Okay, so we've pretty much outed him. All that happens now is the judge accidentally slip his name in on a hot mic. Works for Delta. We had a slight echo. I believe we fixed it on the court side.
Yes.
Are we ready to get started? Wait, Miss Hilton, you said you wanted to check the audio.
Yes, please.
Will you hit play for just a moment?
Your Honor, I object. Whoever recorded this should be charged with a crime.
interference something that you've experienced before, or is it something to do with your broadcasting it?
I think it might be the broadcasting. Your Honor. Earlier today, it was as clear as day. I could hear every word, so I'm not sure.
Have you attempted to do it on your
Bluetooth?
On your speaker instead of through the court's audio system, which is not great, to say the least?
Okay, what might be happening is I don't mean to diagnose this for you, Miss Hilton, but the output level you are putting out, it might be a line mic mismatch, is what I'm saying. If you're feeding mic feed into a line feed, line input, or vice versa, we're going to have a mismatch. So now we have no audio while they're working on this. Waiting. I think they recorded this on reel-to-reel back in the day, or possibly one of those wax circles that with the big horn thing. Just waiting for them to bring back audio as they're struggling to fix everything.
Terry was here yesterday when we concluded. She is currently on the stand in Gwinnett. She took the stand at 11:30 and is on now, so we're waiting for her to get off. But that would be one of our last witnesses. I think we're at 3 remaining.
Forgive me, Dr. Terry is the ME?
ME, that's right.
Okay.
Get a lawyer right there popping something, a pill.
Device not found. Ready to air.
All right.
Connected to PHEPL 540039F10.
No, it's connected.
Now play it. See if that's any better. State gonna rest today? I hope so.
Later on, there's a couple months towards the end of that fight, and she got to try to work in his fault line up there on Yorville. And she had a guy that could that was there.
I think we're ready. Okay. So are we ready for the jury?
Let me just clarify.
Ms.
That
Hilton?
is,
Yes.
Ms. Hilton, that is not
Mr.
clear
McDermott?
as day.
Okay. Can we have the jury, please?
That is bare minimum potato quality interrogation audio. I'm offended that you think that's clear as day. His hair looks better than mine. He's missing a scrunchie, or what does he use normally to make his ponytail? He's got flowing locks. In Fulton County, it's clear as day. What is this case about? Jeff Life, JLJ. This is, I cannot say your name for some reason. Jeff. This is a murder trial, and it is a similar trial to the last one we had, where the body was cut up into pieces and hidden. The husband is charged in the murder of his wife. Fun fact, the wife was the daughter of a convicted serial killer who killed members of his own family, including 2 people in his own home. And that serial killer had the aid and assistance of his wife in both planning, carrying out, and hiding the bodies, or disposing of the bodies.
Be seated.
It's a wild case.
Good afternoon, ladies and gentlemen.
Wait till we tell you about
We
Waffle
are ready
House.
to go ahead and get started for the afternoon session. Thank you all. Ms. Hilton, the state may call its next witness.
Thank you, Your Honor. The state calls Mike Sprinkle to the stand.
Mike Sprinkles?
Come on up, sir. When you reach the witness stand, before you have a seat, if you'll turn and face the deputy and raise your right hand, he'll swear you in.
Swear I affirm that the testimony that shall I give truth, the whole truth, and nothing but the truth. I Please state the spell your full name for the court.
First name Michael, Michael. Last name Sprinkle, Sprinkel.
And good afternoon, Mr. Sprinkle. How are you currently employed?
I am employed as a Deputy District Attorney at the office of the Fulton County District Attorney here in Atlanta, Georgia.
And how long have you been with the District Attorney's office?
Since June of 2011, so about 14 years.
And what unit do you work in?
I am in the unindicted homicide unit.
And what are your job duties and responsibilities as a deputy in the unindicted homicide unit?
I oversee the unit, the unindicted homicide unit, which screens the incoming homicide cases that come from the various jurisdictions in Fulton County, and I screen them specifically prior to their presentation to the Fulton County Grand Jury.
And in that role, have you at times worked on cold cases?
I have.
And within those files, have you had to enhance audio or video recordings to assist with your investigation or looking into that case?
Yes.
I want to direct your attention to the Melissa Wolfenbarger case. Did you have any occasion to work on that case?
I did.
And within that, did you have the occasion to enhance a September 12, 2001 Henry County interview video?
Yes. Well, yes. It was on I obtained the original video. It was on a video cassette, like a VHS cassette. I had a VCR in my office. And I also had this little USB device that had an RCA connection on it. So essentially it made it so I could hook the VCR up using RCA cables to my computer and then record it. And in doing that,
those are terrible.
Extracted the audio specifically off the VHS cassette. And I don't recall what exactly I did. I just know that I created an audio file that I could hear better than when I watched the video cassette originally.
I don't know what I did.
And was that able to help enhance you listening to the audio that was on that video cassette?
Yes.
Okay. And have you had the opportunity to review that audio that you extracted in preparation for your testimony today?
Yes, there was a disc, an optical disc that was handed to me outside the courtroom. There were 2 files on it. And I listened to them, and they were the audio files. There were 2 of them. One was an excerpt from the audio file that I created, and the other was the full audio file that I created.
All right. Yeah, permission to approach?
Excuse me?
Permission to approach.
Go, yes.
I'm going to show you what's in mark that states it's 73A. Do you recognize 73A?
Yes, this is the disc that I just described.
And did both the original audio and appear to be the full audio that you extracted from the September 12, 2001 video?
Yes, it hadn't been altered or manipulated in any way.
Okay. And then was there a redacted version on there as well?
The redacted version was on there. That was the excerpt of the original, yes.
But you altered and manipulated it.
At this time, the state would like to admit Stacey Exhibit 73A.
And you don't even know how you altered it and manipulated it.
Objection. 73A is admitted.
Permission to publish.
Permission granted. Ladies and gentlemen, I'll just remind you, as I have when we've played audio for you, there may be things that have been removed from the audio. You may perceive that, and I'll just remind you that the fact that redactions have been made is not something that you should consider, and why or what might have been said or why the court caused it to be redacted is not something that you should speculate about. Thank you all.
Where do you live right now?
Your Honor, may I object?
Yes, sure. You pause that, please.
Pause what? Has it started? I'm sorry. Sir, can you push whatever buttons you pushed last time to fix it so it worked? This is terrible. We're listening to him. Let me tell you what he said. He said, I did it. I'm guilty. I'm guilty. I'm guilty. Are you sure that's what he said? Yeah, I have a perfect recollection of that. And you heard that in the recording? Yep, that's what I heard. This is terrible. This is considered clear. I want to know, first of all, he used a USB to RCA converter to extract the audio from a VHS cassette. And then he did something, he's not sure what, but he was able to tell what that was said. USB and RCA. I have yet to see a device produced commercially that does this well. That makes a faithful transition there. It sounds like something cheap, and about the audio is any indication, probably destructive to the audio. Sounds like it's Waffle Housing, yes. I'm going to add to the counter for this one because apparently anything goes. I don't know what I did, but it worked. Cheap and tawdry. Yeah, that works. Isn't there a transcript of the audio? I don't know how you could get a transcript of the audio if that was the original recording. He manipulated it, yes. Do you delete the transcript for your videos after a certain time? I don't delete any. Well, I haven't deleted anything. As a general rule, I haven't. I can probably count on one hand the number of things I've deleted from a channel. It's usually when something happens in court that we should not have, and the court orders that it has to be removed, or I know better and remove it myself. Very few times, a couple times, family members have reached out to me and I've deleted something from a video. But I do try to keep all the chat and everything running. Sometimes I click the wrong button and it doesn't save chat. But the transcript said, Judge at sidebar. What was that? Was that a mumble rap? I think so. I haven't been watching. Who's winning this one? Miss Hilton is trying to explain, which means she's probably losing. But it is the defense's objection, so he went first. What's pathetic is this is the best evidence they have. Tammy, it takes time for chat to be, like, it takes 24 hours for it to become available. So you have to wait longer before YouTube can process it. Immediately after the live stream, it's not available.
To ask you to step out of the room for just a few minutes. Thank you for your patience.
All right, judge says we're going to rumble. Jury out. We're going to fight about this in open court without the jury present.
Just let the jury get clear and then we can.
Then it's game on. What is supposed to be on the recording? People talking is what I've heard, but as of now, not sure. Sprinkle Man was in YSL as well. Can we do trivia? The trivia question is, what was in that recording?
Clear. Mr. Sprinkle, I'm going to ask you to step off and step back outside, please.
Yes, Your Honor.
Thank you.
Miss Hilton, why are you playing crap?
Okay. So just to make a record, the nature of Mr. McDermott's objection was that what was being played for the jury for, I'd say, somewhere between maybe 30 seconds to a minute really wasn't audible, right? It just sounds like Charlie Brown's parents, right? Mom, 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 mom. You know, we can tell somebody's talking, but you can't really tell what they're saying. I don't know if the fact that that speaker was facing the jury made it more audible and understandable to them, but I didn't get the impression that anybody really understood what was being said. Mr. McDermott's objection was that it was audible at some point, and if it's audible, it ought to be audible in the courtroom or it ought not to be played. We discussed some variations of how we might address this issue, and ultimately, I decided to take a break because I think I understand Ms. Hilton's representation to be that at various times she has listened to that recording and that it is in its, I guess, the point of Mr. Sprinkle's actions of enhancing the audio was to make the entire thing audible, understandable. And if that's the case in some media, then y'all need to take a minute to figure out how to make it audible in this courtroom. And if it can't be made to be audible in the courtroom, then I'm not exactly sure how it's admissible if we can't understand anything being said. The fact that he gave a statement is already in evidence on that date. So.
You know, after parents locked me up like eight, 9 times, you're still a fish bag, like people over there too. So I don't have a good relationship with them at all. I'm kind of curious about that. That's one reason I ain't anywhere to talk to them. But, I mean, shit, all done. Everything was really, really managed for us a while. And you got that system. I know we live in, I don't know what exactly we live in. We live in Atlanta.
You live in Atlanta?
You all understand that?
That was just we worked in the Walmart. And,
I mean, I can understand it better than I could before, to the extent that audio quality is always an issue. Best part to the middle?
Call your mom or your sister or somebody.
Call your mom.
That's 10 minutes in.
She's there. I mean, she's probably around that same area, but I don't.
That's 16 minutes in.
But I mean, these people are all like me.
That's 20 minutes in.
If it's the same quality all the way through,
Anybody I'm telling you right now,
and the judge thinks that's all.
Anybody that's around there,
That's about 25 minutes in.
there ain't no way I'm going to
Okay.
Please no, Judge. Please no.
No, I just want to start at the beginning just to see how far it went. Thank you.
Got a suggestion. Get Mr. Sprinkle in here and have him push those buttons to make it audible again.
So it's probably about 1:20 where it gets clearer, about 1 minute and 20 seconds.
intros him. What I can hear here is him just getting his name, where he lived, and that's the first minute.
I met her to go to mine. She showed my house.
I met her. She showed up at my house.
Okay.
That's the first time
So we would propose starting at about 1:30, a minute and 30.
Is there any, forgive me if that's what you've just said, Ms. Hilton, but is there any understanding about what it is that was being said before that no one can understand? Do we not know?
So I can hear what he's saying. What he's asking is his like contact information in the first minute.
Yeah, give us word for
He's
word.
asking to give me a little bit of background of their history. The detective asked him to go back over your history, and then he starts.
I met her to girlfriend mine. She showed my house to school.
Okay. And that's kind of where this is really where he starts talking about their history.
Okay.
And we're at a minute and 45 in.
Okay. So what is the time designation on that tape that you're going to start playing?
I'm going to start it at 1:40 or 1:35 to the end.
Mr. McDermott?
I'm still not happy with the quality of it overall. I think asking the jury to sit through 20 to 30 minutes of that is going to be, its own form of torture. And I don't necessarily see the probative value of it because so little bit of it's audible, you can pick up bits and pieces. That's not a fair copy of an interview, I don't think. It's certainly not anything that would get close to a rule of completeness. So I would still object to playing it at all. If the court has determined that that's audible enough for the jury, obviously that's your call. But I maintain the objection not to play it at all.
Okay.
Judge,
and furthermore, we've heard testimony from Detective Stott, who kept fairly detailed notes about this interview, and he gave us a pretty thorough rundown of everything that was said in it. So I'm not sure what's going to be picked up from listening to this tin can version of it.
Ms. Hilton.
Yes, Your Honor. Probably Mr. Stott couldn't remember certain things that I asked him as far as dates. I asked him specifically about some dates, specific things that Mr. Wolfenbarger said about relationships, that he had with the Patton family, and there were just things he did not remember. And I believe I asked him towards the conclusion, does the video contain the entirety of your statement? Would that be the fairest representation of your interview with Mr. Wolfenbarger? And he said yes, because everything that I asked him, he did not remember the full contents of this audio, of this video interview from 2001. And we do think it's relevant to play the video was in. What we're now doing is trying to make sure that the jurors can hear the audio from that video so that if they wanted to play the video, they could play it in the back, but here is the audio that goes along with this video. And the redactions are redactions in which we advise the defense that we were taking out certain portions. The portions that are redacted from the video is Mr. Wolfenbarger's criminal history. Those are the things that are out, but everything else is what Mr. McDermott agreed should be in. Matter of fact, he asked for us to add something in that we had taken out that referenced Mr. Wolfenbarger's criminal history. So we believe that this is a depiction so that the jurors can hear fully what Mr. Wolfenbarger said in 2001.
I guess my final point would be that, I did agree to some redactions. Those are not the issue as we were talking about here. My final point would be this. We're playing something for a jury that we're all sitting here listening to, and we can pick up bits and pieces. Some of it we can hear, some of it we can't. Some of the stuff in that interview I consider exculpatory and good for the defense. Other things I'm sure the state considers good for their case. We have no idea what the jury is going to be able to hear or not hear out of any of that. And it's just not, you're taking a crapshoot. And I don't want that going before the jury. If we have a clear version of that, then I wouldn't object to it. But there's just no way of telling what anyone's going to pick up from that.
Judge, grow
and
a
that's
pair
not
and
a
stand
fair
up to
thing
this.
to put before the jury.
And I think that goes to weight, not admissibility, Your Honor. They can argue that it's not clear. They can argue whatever. They can blame the state for the bad audio. They can do all of those things. But we can put this speaker up there and they can hear whatever it is that they determine that they can hear, and the defense can do with it as they wish.
I mean,
Judge,
you're not
no.
wrong, Ms. Hilton, in terms of the defense can use it against you if they choose to, right? And make the arguments that Mr. McDermott wants to make. I will say that I think the thing I'm frustrated by, and I blame it on the court technology, not on the state, but the thing I'm frustrated by is if you can play it at your computer and hear it, right, and not in this weird garbled state that it is now, why can't we? That's what I'm frustrated by.
But I think as I played it a few seconds ago, we were all able to hear it. I mean, I don't know how this both of
Is that what the audio sounds like when you play it for yourself at your computer or whatever?
Yeah, I mean, yes, I can hear the words.
Except that you're telling me that, like, you're telling me things that are being said at the beginning of the video that I can't hear. And that's what I don't understand. And it's not that I can't hear it, it's that I can't make out anything, and I don't understand why you can if the court can't. And is it an audio quality issue because you're listening to it, on your computer or whatever?
Or are you lying?
I'm not sure, Your Honor. I mean, I can maybe bring this speaker up closer to the court so you can hear it, what I hear, but I can hear it. I can hear him, and maybe because I've listened to it, I know what's happening, and that could possibly be the case. But as we moved the speaker down, and I kept asking and starting at different points, I think everyone heard everything. That wasn't hard to hear. It was the first minute and 30 seconds. But I believe that everything after that, when I stopped it at the various points a few seconds ago, I believe everyone heard, or at least no one communicated that they did not hear what was being projected on the audio.
Okay. Mr. McDermott, your objection is going to be overruled. I'm going to let the state play the audio for whatever it's worth. Okay?
I'll just note for the record that Ms. Hilton stated just a minute ago that she would be willing to put the speaker up closer to the jury, quote, so they can hear whatever they can hear. And that's my argument.
Right, but that's the problem with the quality of videos. Sometimes the ones that were done 3 days ago in a police interview room that's outfitted with appropriate audio, whatever's there is whatever's there, and whatever the jury hears is what the jury hears based on what's there, and that's just a sad fact of life. So your objection is noted for the record. It's overruled. And you're going to start it at the 135 mark? Okay, if you'll go ahead and cue that up at the 135 mark.
It's ready.
Okay, so all you have to do is hit play?
Yep.
Okay. So can we have our jury back, Deputy? Thank you.
I don't like this.
Oh, can we have our witness back too? I'm sorry.
I don't like this because...
Thank you, sir.
And I realize we have bad audio all over the place that juries get to hear. I don't like this because a jury, if you think you've made your mind up, okay, you've made decisions about something, and you're trying to hear something that you can't put together, your mind will try to fill in the blanks. Your mind will basically try to translate what you're hearing into words. It's like us listening to really bad audio. Did they just say? And I come up with something that sort of sounds similar. Once I say, did they just say that? Everyone will say, yeah, that's what I heard too. Because I put it in your head. I don't want jurors to be like coming up with their own, I think this is what I just heard moments. If I called this court, if they called me in, I would tell them, Your Honor, this audio is not suitable for use in prosecution. Stand up to it. Force the prosecutors, force the investigators to upgrade their gear, to do a better job. Somebody's life's on the line, okay? And you're playing Charlie Brown's Christmas and expecting the jury to make a decision based on what they think the teacher said. I think it's terrible. I wouldn't help them. Sorry. DSN, thanks for the super sticker. I appreciate that. I did. I counted on the anything goes. We're up to 31 now. I think defense should have objected to the manipulation as well.
Mr. Sprinkle, you can go ahead and be seated. Sorry for that delay, ladies and gentlemen. Thank you. Ms. Ms. Hilton, you may proceed.
Thank you, Your Honor.
I remember to a girlfriend of mine, she showed up at my house just going up and home.
I met her to a girlfriend of mine. She showed up at my house.
She, you know, going about the other parents, they go on, we went away together and come back and get good by the whole day. Just about 95, we got married.
The witness doesn't understand. Look at his face.
So I don't have a good relationship with them at all. Kind of figured out that's all they know. I didn't want to talk to them.
Let me see if I can get rid of some of this courtroom noise.
I'm going to put it on. Yeah, really mad at me for this for a while. No, we living, I don't know where that was living. We didn't live in Atlanta. That was just a different looking Waffle House.
Waffle House.
Okay, okay. Her sister kept telling how bad she had a lady and how long it is, how bad it's not. You know, you kept putting thoughts of this in her head, like, you know, you didn't real, all that is happening and all. So, well, I was in a shifty mode, you know, drugs and like that. And get her and sister got smoked in. Like I wouldn't know this kind of thing. Then, you know, this time went on, and, you know, she just, cool.
Sorry, the lawyers were whispering, so we have to mute that.
Up until, you know, later on, there's a couple months later, you know, got a fight, and she went to work in this Waffle House up in Yorkville. And she knows the guy that took over there. I guess they got screwed or whatever, or not. You know, she come on, she put her out the door, other Waffle House, but yeah, he worked there. Just had it with him, and she stayed long for 3 or 4 days at a time, but come back, we had a restoration. And then, she just come back one day, and she said, give it down on top of it. I guess all this happened about the same time as this was right around Thanksgiving, remember that? And I was thinking it was
right around Thanksgiving.
Anyway, I'm going to say, she come back. She doesn't want she would come back good with me, but she stayed there like a week. I guess that was just to get her stuff. Because when she stayed there, she left again. Come back a couple days later. She come back and we had a long talk that night. The next morning I woke up, she didn't got our stuff. Left. A buddy of mine has been on a water train, but I had a stroke with his he got off the 5 points and she kept one over. You got to have 2 kids. Where was your boss last night? And so 98, somewhere around Thanksgiving, that's where about 12 weeks, that's how we all got together. He just years. I'm saying, yeah, it's in 99, yeah, this one, you know, I got that time. So, what would you do?
Is this better right now, or is this? This is my version. I've cleaned it up a little bit. The other one is how court sounds.
That time I was at 8.3.
Another Waffle House.
The first one she worked with, I really don't know why she, to this day, I don't know why she just really, like, them in the young line. She got on water train all the way up to Georgia. And the only reason she gave me minutes at that time was because it was right off the water train. I mean, there's a bunch of them there. I mean, to this day, I'm thinking, that's one thing her and sister knows, or she never let me on her that. So, I don't know if this was guys she knew from before or what. I'm not that. If you say we use it, I would. So they really would be sporadically, yeah. I'll say almost as much. I will say so, because it was right around, it was almost Christmas, I reckon. Then after she left, I didn't hear too much from her for a couple months.
After she left, I didn't hear much from her for a couple months.
April the following year, which I guess would be 9.
April the following year.
And I was coming down this street, almost about the line like that. But right there, right where the train station was, and I was coming down through there, and she was walking in the road, and me and you seeing a white girl, blowing the horn, just, we're 90 degrees around there, But I stopped and I blew the horn at her, and I got a road about 50 cents around from that time. I knew it was. I couldn't believe it.
He was coming down the street, and she was out there on the road.
I guess my sister could tell you how she looked. You got a picture how she looked when she was right. That was like last year, after we got married. After that, she cut all her hair short, dyed it, and started smoking, so she was totally different. When I said so much, anybody she wants to wait in the middle, she could leave and look for her heart. We stopped and she said she wanted to talk, so we went to Taco Bell, we went over to the whatever, And at the time she was like 9 minutes late, I'm going to come back home. I'm like, we're going to the emotional stuff, whatever, we're going to take the news and just like this, and it's better off. I just move on. It looked like she had tracks and stuff from home, but they just, I don't really key up on all that, Look on all that. She looked awful. She was like, telling me what was going on and all that. Basically, what had happened was, from the conversation I had with that time, she got rid of this guy, right? And you see where she kept putting talk to me, like all these people were living in one house, like 5 or 6 of them in one house.
All these people live in one house.
Just the party lifestyle, they would go out and party and party all the time. And she was like, she felt like she was missing out on all that. Then she said what she wanted to do, and just that wasn't right. When I told her that time, I thought I should get them to really do, call your mom or your sister or somebody.
Allie B, thank you very much. OG.
I wish you communicated with the kids. Never, she never did. When you got my mom, she never really, ever, from the time that she found them over, she never really called me anything for nothing. From day one, it's all I did. And she didn't.
I believe this witness and the defendant are talking.
I wouldn't do that. when she was at our equipment, and trouble up whenever you saw her, we found her over there, she was still hanging out with that group. She was part of that one thing that we're talking about.
The lawyers whisper, so we can't hear anything, which is a blessing.
Real smart, she's a lot of smart student, real intelligent that way, but as far as, you know, she was real naive, you know. I don't know that way, you know, but not quite that. She was basically, if you could put an idea in her head, you would think about it, she would swear that's right. And that's, I guess that's when she has so much problems, you know, going away all the time. But she was a real follower. When we saw it now, we still working with it. I really didn't want to know my whole mind. And it was really just hard for me to sit there and talk like that. You know, I was trying to. It's like she was trying to go into all, you know, all of it around that, and I just couldn't, you know, I didn't want to know no more than I had to know. I just didn't. But there's no way I believe the skin color and all. That's the whole reason I ain't. Or stuff like that. She just feels like that much with the kid. Everybody else that she did talk to, you know. That's why I'm saying that she called. But I've never seen it. I've seen her call mom once or twice. I mean, I never see it like that. I couldn't. She said she used to send her mom calls and all the time, and I wasn't doubting it. You know, I don't really know. You know what I mean? You have a dad name? I do not. I only got it for one other certain fact, his name is Mike. I remember that. As far as his last name, I think.
More whispers. Keep whispering. It's peaceful this way.
That she was messing with. I know the other night she lived in Shalford Lodge. That's where I went. Whenever her mom used to say she was coming back with me, when I went there to pick her up, we lived at Shalford Lodge. That was where I went to get her. But she said that was because, you know, she was having an argument with this guy or whatever, I guess. That's where she just, when she went with him, that's where she was. She was all up around that area. I mean, we never knew anybody in that area, you know? What would she be doing now? I can't find anywhere. I can't find what she's working with. You know, for look on Social Security, taxes, whatever. But the only thing that I know that she would, like I say, we've been here. That's all I think that I really don't know. It's just my opinion. If she went through, because to this day, she's still married to me. I'm just now, you know, I guess going to the Lord for her kind of life. The only thing I can figure she might have done is went through changing that, but she never got to do that. The only thing I can see is that she changed her name when she got married. And she changed everything.
Changed the name when she got married.
Yeah. It was never real easy to work. She had probation. She was on probation. Yeah, that, and I got all kind of, heard through mail with it once and said they want to vote for that. Or I guess you just look at the court for a few things or some kind of. There was another detective inside you that was looking for. There's a man and a woman from the court. Okay. Looking for they're not the same kind of page, I don't know. try to lead in the direction. She's very, I mean, she's probably around that same area, but I don't have no way of even talking to her. Everybody that, and we didn't have any friends or anything, but we don't, you know, we associated with a whole lot of people. I mean, anybody else, any other family member, I would probably know anybody that she would talk to, you know. There was sometimes she would talk to my old sister, and that was, you know, because we didn't really know anybody. We lived in the black neighborhood, you know, we had no friends around there. And, you know, we go like get meals and stuff like that, and, you know, she had all this history. It's my understanding, and I haven't ever seen this, my little sister and mom told me that she wrote my sister a note. Was this or had this note or whatever, you know, they're taking it, but I didn't get to see it. But my sister told me that she wrote a note explaining all of what was going on. And this apparently is after she left me. So, I don't have too much of it. Where she said, I don't even know that. Canberra National Marriage. You're not going to see the care about I mean, and when Pat was and come over and all this, you know, you can ask my sister, you can ask my mom. I thought, my mom wasn't too bad around me. My mom was taking me to the under and she goes like, if you answer, I know you get. Anytime I got to do, you know, it was just hard. The only time I really had to do come stay with me is when I feel very busy with the system, so then come stay with me for a week. That's it. That's, you know, I don't know if I want to you got to that's really hard. You got to approach her, that's the way you approach it. Take care of you. Everything you don't find everything. But yeah, you can learn private school and everything. I mean, I don't know. And I mean, I would have called her mom. You know, and talk to them, but every single time in the past that I've ever seen these people, and then we locked up like 8 times, her husband had stopped and beat the crap out of me, and I was on the parking lot like that. That's the last time I ever seen, you know, and I'm like, I'm trying to go over there, you know, you know, but I swear, after you stop coming by there, because every time you see you come out of home, you know, I call the car, over there, and because a lot of times with the mom, I called her to start with you, but she went out. I kind of got the impression, you know, that this girl had gone, she wasn't involved with y'all, and mom was it. Y'all get involved with it, you know, if I met the wrong thing, y'all, and you got to understand that, but at that time, I kind of wondered what's going on with it. I swear, I believe she got in touch with her mom. Her mom was making it out like she had a real good relationship with her. She did. They really did. They didn't never. I mean, I guess she was trying to build a relationship with her sister. I felt like she would have gotten to her sister a million times before she got to her mom. I mean, the last time I noticed where her sister was, she was living pizza. And I think, and it's my understanding that I don't know for a fact, but it's my understanding her sister moved. But I don't know that. But I mean, these people are always hating me. Her sister and all. And her sister, you can look at me anyway, but her sister has always been on that track. And I hope, you know, she got on anything better. Because her sister went through one time and finally to their car. And told all their family that I come over there and got their car one night. And just come up later on that the night one, I just come and told them that we had the car. I don't know. anything happened to her? They could either, I don't know, commit suicide or somebody who's hanging with her, killed her or something like that? I don't think she committed suicide. This girl had a really strong, that's one thing I can say about her. She was really, she had the, I don't know what word I'm looking for, she had the endurance, you know what I mean? With her sister, when she was coming up, her sister like had a baby in the bathroom and didn't tell nobody about it. She put the baby in the car. And Melissa found it like 3 days later in the gym bag. You know, that kind of much more strange. You know, pretty good. You know, she was molested by her dad's best friend. You know, there's nothing ever get done about it. She got a really strong mentality. I don't feel, you know, I'm not being wrong with her, but I just don't think. As far as the label, she can't be mad at all these people. I don't, you know what I mean? I don't even know if she got any of these people. Not that something bad with being her husband, it's bad. There's something bad for me. But I swear, I don't know how. I really don't know if her sister put her in the up there, or how she got in the door there, and how, period. You know, we didn't know things like this. Then later on, I mean, a buddy of mine had moved up that way, that was not, it didn't have anything to do with her. What name would she find out not before she tried to get it? Because, I mean, the simple reason why we get in the U.S. with family name. Because she can be anything. And she knows that she's got the real when she got, she can do it. I just thought all up. I mean, it's like, I think things would be a lot different if we would know a lot of people, you know, if we stay in like Rosebud, little town, you know, we look through everybody, or something, and we kind of do this, we would look alike and know everybody. Your relationship, you know, with Miss Pat, and good y'all go on, and she, how was it hateful to y'all? I mean, how did she talk to you, man, if you were like, you know, I mean, I come up, you know what, this is the first time I ever really talked to that woman like that. Ever really, I mean, she's always, it can hate me. It really do. She cannot stand me with everything. You know, and I all, you know, literally, right after we got married, I will, you know, I just called her up and tell her about that, because at that time she was telling me all everything, what, you know, happened and everything. I mean, today was the first day that I really, you know, kind of, we really talked, you know, and it just blew me away that they had not talked to her at all. I guess that's mom, because I was there in shock. I'm like, there's no way. I mean, I used to work with her daddy when we first got married, and I used to walk with them. I'm like, what? These people are real bad time. That's one thing I said about them. They did, I don't know anything with insurance fraud and stuff like that. They ever come out and accuse you, so they think you did something to her, or, you know, something like that? I haven't talked. I try to stop. I try to avoid these people like play. If any kind of interaction I've ever had with these people, if you got me beat up, I put them in jail. And for me, I mean, it's kind of a strange thing when you know how we even got married, because it's like, in my mind, it's just like a goal, and it's like, I hate married this girl, you know, I'm still with people, and they don't, you know, I mean, it's just crazy. Well, I don't know, I mean, it kind of looks like for a while you could have done something about it or whatever, you know, because you want to use the motivate and get kind of stories from the happening, you know, all those things, get the spiritually, that's like you got those things. You can ask me, you can go to anybody, anything I'm telling you right now, you can ask anyone, like I mean, anybody that's around there, and I can tell they do the same. I mean, there ain't no way I'm going to work on you. So yeah, we look at another 1.1 in the groups. So then of course I'm like, you know, she's it all. When did you find out that she was reported missing? Or like that program just feel like me I'm doing that? I think the very first time you come out of it, I think you spoke down, I don't remember, is that correct? I think you spoke on mom. The one like that. Showing me like that. I mean, that's got to tell you right there that she didn't have a relationship with her mama, and her mama saying she did. If her mama waited the whole year, you know what I mean? There's no way. So that's, that's where it came out of. It just looked like a situation where you got somebody that goes off and does whatever they do, maybe a drug addict or something that has, maybe they're going to do things.
I keep hoping it'll get clearer. It's not.
It's so not after a year, you have to kind of make it up to you on the small amount out, but you don't. But, seems like somebody, like this, or something bad that happened to her, and I mean, that might have been all the, I've been sitting here, and you don't know how long I've been sitting here just going over scenario after scenario, trying to figure it out what it is, especially now, man, that's what me now. After you told her mom, and she didn't tell her mom. But the only thing which I was sitting there all eager with, is we did this thing, we changed the name and everything, was the only thing I kept saying is at the time that we had to set up with making money and things, all that, and really not and proud of that. But he was like, you got to cut off everybody you know that we wrong. I could kind of say that. If the need has happened. And if you put that, she just don't have to. All that she knows she's a big part of that way. She wasn't able to buy a lot of that way. She could go to that. But she had to cut down to it, right? Well, the last time that you saw her, she left for Christmas, so we saw 15 months later, talking about February, March, and all of that, early next year. You can have one left in the life. From that picture right there, and I bet, I'm going to look her, and I think there's a picture of my grandma. Last time she was with my grandma. She had short, cut her hair off short, and bright green. And she did that for the time that she got back in, that's what I'm saying. So they were saying, I mean, she had taken, she had dyed her hair several months before, but then right there towards the end, and especially when I see her April, her hair was real short, real bright. It was like, they look odd, she definitely stood out. But I mean, she don't do nothing like that. Not like that. I don't see it, man. And all this time, I swear I thought she was, at least it makes her sister. That's the only reason I never really could see it harder. But sister, mother and I had her, the real same sister, one child. But at that time, I didn't even have a real relationship. I didn't know that sister. All this happened. You don't come in with family or something that is probably about your I live in the other part. Somebody buying things and doing things and all that. That's really very much.
We stopped at 3035 Road.
Thank you.
Thank you.
No further questions. Mr. McDermott, do you have questions for this witness?
No questions for this witness.
Yeah.
Thank you, Mr. Sprinkle. You may step down. Ms. Hilton, the state may call its next witness.
Thank you, Your Honor. The state calls Rosa James.
Okay, part of the problem with that audio is that Miss Hilton was playing it on a Bluetooth speaker plugged into her computer, played in the courtroom, which was picked up by the same mics which are picking up the air conditioner and every other piece of machinery in the courtroom.
Quick 2-second bench.
Sure.
Come on up. I'm going to blow my nose in front of you. She'll wait. She'll wait. Set that tissue down. It was recorded on a Little Tykes recorder. Same thing. I think Donna's going to get better, though, once the trial starts. We're going to get better audio, I think. It's over. It's over. Can somebody put in chat the audio is over? For anyone who has bad audio, I need somebody to type this in chat. For anyone who has bad audio, skip to current. You won't miss anything. There we go. All right, you're good. Thank you. Thank you all. Oh, it's in the bat signals. Kelly H., thank you very much for the super sticker celebrating with the Cape of Justice. The audio was over. So, yeah, let's see. Of course, we don't know what comes next. I don't think it's another recording. Got another witness. Judge is just chilling. Looks like she's got a little cup of tea going there, possibly. Let's see a little stir in there. Can't quite see what it says on her mug. It probably says, "Get your hands off my mug." The judge looks over at the camera, gives him the side eye. You looking at me? Yeah, we see you. Joel calls it a Fisher-Price moment. Yeah, that was terrible audio. I think if judges would stand up and say this, I can't hear it, so I can't make a ruling on it. If it's bad audio, it's not coming to court. Force police to get better recordings. We've got the technology to do it. I mean, it's pathetic. It's like we allow banks to keep their 1970s security cameras. And then when they get robbed, they're like, help us solve the case. Here's a picture of the thief. And it looks like Steve from Minecraft. No, sorry, you're on your own. Call your insurance company. Maybe they'll cover the loss. You've got to do your part so we can do ours. Chris Wallace, gifted a membership. Thank you, Chris. Appreciate it. Judge makes a little note. Mental note. That audio sucked. Underline, underline, underline. Okay. Now could we proceed?
Witness stand, ma'am, and when you get there, if you will, before you have a seat, turn around and face the deputy and raise your right hand. He'll swear you in.
Do you swear upon to the testimony that you're about to give the truth, the whole truth, and nothing but the truth, sir? Yes. I'm going to have a seat.
Ding dong. Please mute.
Rosa, R-O-S-A, James, J-A-M-E-S.
And she brought her Stanley jug.
My understanding was after you had qualified.
Oh, okay.
Or attempted to qualify her.
Thank you.
Thank you.
Expert.
Good afternoon, Ms. James.
Good afternoon.
How are you employed?
I'm currently employed, self-employed at my consulting company called Sania's Place, LLC. I was going to spell it. S-A-N-I-Y-A-H Place, LLC.
And if you can tell the juror your job duties and responsibilities at your consulting firm.
So my job duties as a consultant is I'm a researcher, practitioner, and also a trainer for intimate partner violence and gender-based violence. I also do sexual violence and child abuse. I do trainings, I do presentations, panels, whatever the community needs me to do, and I also do expert testimonies.
And how long have you had your consulting firm?
It's been open since January of 2023.
And if you can tell the jurors, how long have you been in the space of working in intimate partner violence?
I started working in the intimate partner violence movement in 2012.
Okay. And just tell the jury about your education, your job training in intimate partner violence.
So I started working in the intimate partner violence movement in 2012 at Harbor House of Central Florida. That is a local domestic violence center in Orlando, Florida. And then I continued throughout I continued to the Florida Coalition Against Domestic Violence, and then I moved to the Georgia Coalition Against Domestic Violence, and that's how I got to Georgia. My education background, I have a bachelor's of Science and Legal Studies from the University of Central Florida. I have a Master's of Social Work from the University of Central Florida, which is a clinical program. I also am currently finishing up my PhD at Clark Atlanta University in the social work program, policy and organizational leadership. From the Georgia Coalition Against Domestic Violence, I transitioned to the District Attorney's Office as a domestic violence trainer in July of 2019. And then when Madam DA came into office, I became a senior advocate, senior victim witness advocate, the domestic violence trainer, and domestic violence expert.
And you said you're currently getting your PhD at Clark Atlanta?
Clark Atlanta University.
And are you currently at the dissertation stage?
Yes.
What is your dissertation on?
My dissertation is on intimate partner violence, Black women in service delivery of the local domestic violence centers in Georgia.
Now, you said that you served as a trainer at both the Georgia Coalition Against Domestic Violence and the Florida Coalition Against Domestic Violence. If you could tell the jurors, what type of training have you conducted?
So the foundation of the trainings that I conducted at those two coalitions, they statewide coalitions, is I trained advocates to service survivors of domestic violence. And also these trainings lasted 3 days. On top of that, I had to train the community members as far as healthcare, different systems like healthcare, law enforcement, even in Florida, prosecution offices, any community members throughout the state of Florida and throughout the state of Georgia about domestic violence. I also trained advocates on protective orders. In Florida, it's injunctions. We train them how to be legal advocates in a sense where they have to help survivors with their injunctions as far as helping them through the court process. And also I've done trainings on the queer community and domestic violence and basically a vast majority of intimate partner violence, child abuse, and how all that relates to gender-based violence.
And over your years of working in the field of intimate partner violence and gender-based violence, have you met with and spoken with victims of intimate partner violence?
Yes, I started in 2012, and that was immediately contact with survivors and through face-to-face trainings, hotline calls, well over 20,000 contacts with survivors of domestic violence.
And I said victims and you said survivors. Tell me, why do you use the term survivors?
So in our world and in the movement, we use survivor because the survivor is a term of endearment. And also some survivors, they use thrivers. They have thrived through the domestic violence. We only typically use victim in this realm, or where I am in the science realm, in the advocacy realm, if someone has fallen due to domestic violence, a casualty.
And you talked about having over 20,000 contacts with survivors of domestic or intimate partner violence. Has those interviews and conversations and interactions assisted you in your understanding of domestic violence relationship dynamics?
Yes.
Now, over your course and working in the field as well, have you met and spoken with offenders or abusers?
Yes.
And can you estimate for the jury about how much contact have you had with offenders or abusers?
So I've had a year of contact with what we would call perpetrators or abusers because I taught in Florida batterers intervention courses, which is a 32-week-long course that the courts in Florida mandate that if you receive an injunction that you must take.
And have those interactions, those trainings, informed you regarding your understanding of domestic violence and the dynamics of domestic violence?
Yes, it has.
Have you ever testified in the state of Georgia as an expert in domestic violence?
Yes.
How many times?
So Florida has been 27, and I'm about to do the math. I want to say around 47, 48 times in the state of Georgia.
Your Honor, at this time, the state would like to tender Ms. Rosa James as an expert in domestic violence relationships, and domestic violence relationship dynamics.
Mr. Samuel?
We'll reserve word here for cross-examination.
What?
Okay. So, ladies and gentlemen, Mr. Samuel, come here, please. Miss Hilton, y'all both come here.
The judge is like, you
Would
said
you like
what?
me to step out? No, you're fine. Thank you.
Either I accept her as an expert witness, and she gets to answer questions only experts get to answer, or I don't. And you saying we reserve for later, it doesn't work like that. That's another anything goes. We're up to 32.
The state is offering, excuse me, I'm sorry. The state is offering the testimony of Ms. James as an expert witness. And so at this moment, I'm going to just instruct you generally that people who testify as experts are testifying because the proponent of the evidence believes that they have specialized experience, training, knowledge in a particular field that's not common knowledge or known to the average citizen. And the law permits a person who is testifying as an expert witness to give their opinions based on that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise, and testimony of an expert like that of all witnesses is to be given only such weight and credit as you think it is properly entitled to receive. Thank you. Please go ahead, Ms. Hilton.
Thank you, Your Honor. Ms. James, can you please define domestic violence for the jury?
Yes, the definition of domestic violence is a pattern of coercive behaviors to gain and maintain control over your partner.
A pattern.
And based on this, your training and knowledge, how familiar is the public with the issue of intimate partner and domestic violence?
So the public is familiar with the concept of intimate partner violence, specifically the physical aspect, but the science behind that, the science behind domestic violence, the public typically isn't well versed about what's under the iceberg, typically just above, which is physical violence or any type of sexual violence.
And over the course of the years, has there been some type of increased knowledge with the public as it relates to people watching kind of like true crime television?
Yes, it's specifically, the boom of the internet is information that's there, and through the true crime or any type of documentary, yes, the public can access that information.
However, in your experience, has the knowledge that comes from, say, internet or from podcasts or true crimes, is that the full knowledge or understanding of the science of domestic violence?
No, it is not.
Based on your work in the field, what are some common misconceptions regarding domestic violence?
So the biggest misconception, if the survivor leaves the relationship, the abuse will stop. And that is not true. The data shows that's the most lethal time in the relationship. That is when the survivor is under the most danger and most likely to be killed. So that is a misconception. The abuse does not stop just because someone leaves the relationship.
And based on kind of some of the trainings that you've done in your experience, what are some of the beliefs about why an individual may remain in an abusive relationship?
So there's a host of concepts and theories and perspectives of why someone would remain in an abusive relationship. The biggest factor is power and control. This person has exerted power and control, and the victim or the survivor feels as if they have to stay and remain in this relationship. Also, there's a component of fear and protection, protection of children, protection of self, protection of family members. It's many different dynamics of domestic violence why someone will remain in that cycle of abuse.
And are there any is there any research about how long it usually takes a survivor to leave an abusive relationship?
Yes, the research state on average it takes 7 times to fully leave a relationship that is abusive.
Now, are you familiar with the term or the concept of the cycle of violence?
Yes.
How are you familiar with the cycle of violence?
So the cycle of violence is a cycle that shows how a survivor would remain inside or trapped inside of a abusive relationship with their partner.
And is there a demonstrative that you sometimes use in order to explain the cycle of violence, or is it also called the cycle of abuse?
Yes.
You have permission to approach?
Go ahead.
I'm going to show you what's been marked as State's Exhibit number 79. Do you recognize Stacy Exhibit 79?
Yes.
And how do you recognize Stacy Exhibit number 79?
This is a cycle of abuse. It's an evidence-based tool we use in our practice to show how survivors stay in relationships.
And will this demonstrative assist you in explaining the cycle of abuse to jurors?
Yes.
You're at this time to state like the admit Stacy Exhibit 79.
Mr. Samuel?
This is great evidence. They're going to have to be able to tie it in to
79 is
testimony
admitted.
Permission
about the defendant.
Permission granted.
For it to land. Because this expert has not analyzed the defendant at all. So they're just giving like basic scientific level or the study level information. We're now learning how to go full screen. Or just in biggin.
Of abuse and explaining the demonstrative that's on the screen.
Yeah, so the cycle of abuse, like I stated, is a cycle in which they trapped inside of an abusive relationship.
We just switched to Zoom
I
audio.
know that the public is very familiar with some of these terms, such as like, or even the tension building phase, but I want to explain based on a social theory from 1979 of how we see someone staying inside the relationship with the tension building, right? This is right before the incident.
Miss Hilton's like, you thought that audio was bad? Hold my beer. Here we go. It's going to get worse. And now we have no audio, which is also bad.
Physical, economical, it can be humiliation, it could be intimidation, it could be a whole host of things. And it doesn't have to be a physical incident of arrest, right? So that's when the incident happens. In the reconciliation phase, where we're seeing about guilt, right? Sometimes the survivor feels guilt during this phase. This is the phase where I see survivors wanting to release the charges. This is why I see survivors wanting to recant or even fund the batterers or perpetrators funds when they're in jail. This is when the perpetrator, either he apologizes or he blames the victim for what happened to them. And, oh, it wasn't as bad as it was. This is where a lot of the term gaslighting comes in, and it's basically a conversation back and forth between the survivor and the perpetrator where they're getting back into the relationship. It does not have to look like a honeymoon phase where you're getting flowers and all these things. That's why we no longer really use that term anymore, and that's why we use the phase calm. So in this phase, most likely the abuse is forgotten, the incident is forgotten. We just move on with life like this never happened. That's what I see the most in my field, in my personal observation in the field that I work in. It's just forgotten. It didn't take place. These things happen in relationships. We move on. But like I said, it doesn't always look like, oh, you're getting flowers, you're getting presents and gifts, and it's all love. It doesn't always look like that. Sometimes it just looks like we're moving on with life.
And you kind of talk about in the incident phase, it could be verbal, emotional, and physical. Is it usually one of those three, verbal, emotional, or physical?
It could be a whole host of things. It doesn't always have to be fit into that box, because domestic violence is not a box. Every relationship looks different. Every incident looks different.
Now, in the field, is there also a concept of the power and control wheel?
Yes. The power and control wheel was created in 1980. It's a qualitative tool where 300 survivors were interviewed, and we use ground theory, which is a themes theory, to find different themes, well, similar themes, to create this wheel to show the tactics of the perpetrator.
And have you used a demonstrative of that power and control wheel to explain how an abuser will exert power and control over a survivor?
Yes.
Now I'm going to show you what's been marked as State's Exhibit number 75. Do you recognize State's Exhibit number 75?
Yes.
And how do you recognize State's Exhibit 75?
It is the power and control wheel.
And would that help you today in your testimony and explain to the jury the power and control that abusers use in relationships?
Yes.
You're at this time to state like limit State's Exhibit 75 for demonstrative.
This is a demonstrative exhibit?
Yes, sir.
No objection to using it as a demonstrative exhibit.
Exhibit 75 is admitted for demonstrative purposes.
Thank you, Your Honor.
The problem we're having right here is the switcher being used to switch between court and this is using what's called audio follows video.
Looking at State's Exhibit number 75. Okay. Let me remove them.
So when we see the document, we get Zoom audio, and when we cut back to court, we get court audio. See? Okay. I told you.
If you can, and what I'll do is I'll navigate over here. Just tell me when I need to go up or down. So go down. Okay.
To show like the contributing factors and okay. Oh, that's
all right. Mm-hmm. Okay. So if you can explain kind of the wheel itself, and if you could, you may have to step down just because you might not be able to do on this side. Yeah. So to explain to the jurors what.
It's a very easy problem to fix.
What this wheel is, but I want to tell you why it's structured this way. So on the outside, so first, this isn't the first wheel. This wheel has evolved since 1980. And the reason why I use this wheel, because it's a very much gender neutral wheel, because we understand that domestic violence isn't just gendered from man and woman.
Although
right?
you did say he several times.
It's a whole host of genders, a whole host of communities that suffer from intimate partner violence. And it's structured this way because the physical and sexual violence is seen. Those are things that can be seen, so that's why they're on the outside of the wheel. And these are systems that contribute to intimate partner violence, right? Systems, isms, and things I train about when I'm out in the community trying to help people understand how these different systems could trap someone in a relationship, right? So on the inside, we're going to start with using intimidation. On the inside, these are factors or tactics you may not see when you approach or survive of domestic violence. You may not see intimidation. Mind you, these are all inside the spokes. You may not see someone having a fighting look. You may not see someone abusing pets or using weapons as threats, right? Putting a gun on the table is not illegal. You may not see the emotional abuse. You may not see that person being put down. You may not see the humiliation, or you may not even think that that person is being humiliated or being exposed in that moment as a form of power and control. Using isolation. This is very important because this happens very early in a relationship. They isolate you to them and their support system, right? They don't want you to have any outside friends. They don't want you to have any outside family. They don't want you to have sisters, sorority sisters, or whatever is your support system. Sometimes this transfers, like it's parallel to economic abuse, right? Your livelihood. So what I see a lot in isolation is survivors being pulled away from their family, right? Being moved across country, or being told that it's abnormal to speak with your family members every day, right? They're trying to reduce your access to people so that others on the outside don't see the abuse that's going on inside the home. Minimizing, right? It wasn't that bad. What are you talking about? I'm minimizing the joke. I'm minimizing what took place. Specifically on the cycle abuse, the incident. There's a minimization going on during the reconciliation phase. It wasn't that bad. You made it look like it was the end of the world, and it wasn't. Using children. That is a major, major part of why a lot of survivors stay in relationships, because they want to protect their children, right? That is just the natural part of being an adult. And sometimes when there's a separation, because this abuse can continue outside of the relationship could end, but if you have that connection with children, we can start using the children as a go-between. We can start using the children as someone else to continue the power and control and the abuse. We can also use children to harass family members, use children to indirectly affect your livelihood, right? Calling your place of employment.
The witness is over by the jury, so we can't look at her.
Now we use privilege. So this was changed to use.
The lawyers were speaking. They're not now, so we can listen.
We can use the Bible. We can use someone's race, their culture. Privilege can look a lot of different ways. In economic abuse, I always talk about.
This is good information. It's hard information, but it's good information that she's providing here. I think the key, though,
you must have control of all the money. You must make the most money. No, it could simply
they need to tie it to this
tampering
defendant
with a survivor's car so that
effective.
They can't go to work, right? Ruining credit, continuously getting evicted, invasion of accounts. It can look any way, but the whole goal is to take control of your economic livelihood. Using coercion and threats, that's in the definition. I'm going to coerce you to stay in this relationship. Coercion is really used a lot in the queer community. I'm going to out you.
If this is some tough, if this is not good for you, if this testimony is not good for you, you might want to find another place or just turn off your audio for a while. Wait for the next witness to show up on the screen. It doesn't get much easier as it goes along. I would say most people who've experienced
the healthy relationship wheel.
Most people who've experienced abuse are going to hear something that hits pretty close to home in this, as long as we get the audio.
Abusive relationship, will you see every tactic used?
No.
In order to define a relationship as an abusive relationship, does there have to be like a magic number of events or physical violence or a certain amount of times that someone uses isolation to define that this relationship is domestic violence?
No.
Just has to be a pattern of it, right?
How do you distinguish in the field, say, an isolated incident from a relationship that would be considered a domestic violence relationship?
So to explain an isolated incident, we look back at the definition of domestic violence. The definition is a pattern of coercive behaviors to gain and maintain control. That's what it is. And if there is a pattern, it doesn't take, it's an indefinite number, right? We don't have a certain number. We don't have a certain theme for it to fit in. As long as it fits under that definition and that survivor is explaining that relationship from beginning to end or in the middle, patterns of coercive behavior to gain and maintain power and control, or for the perpetrator to exert power and control, we define that as a domestic violence relationship.
Now, is there any literature regarding the various roles an abuser can play during a domestic violence relationship?
Yes. So there is trainings and information out there about men who batter, right? But we still use that foundation for all genders. And in that training and in that information, the roles that a perpetrator will play to gain and maintain that control is the hero, the judger, or the victim. In that relationship, we see that theme continuously circling and circling to show power and control against their intimate partner.
Okay, so you said it's the hero, the judger, and the victim.
Yes.
Can you explain the hero role?
So the hero usually shows up first, right? I'm saving you from your family. I'm saving you from your friends. I'm saving you from economic depression. I'm saving you from food insecurities. I am here to be a savior, to push you forward in life, right? And there's no infinite time on how long that will last, But yes, I'm the hero. I'm here to save this family, and I'm here to save you from yourself. When we think about the judger, let's go back to the hero. I have saved you. And then as the judger, you may say, the survivor may say, oh, now I want to connect with my family again. I feel like it's time. I think forgiveness is the right answer. Then I'm going to judge you for that, right? No, why would I saved you from them? Why would you go to some place where they hurt you? Why would you interact with people who harmed you? I saved you from that. So I'm judging you in that because I don't want you to go over there, right? I want to maintain that power and control. So I'm judging everything you do when it comes to seeking outside support. And then the victim is, this is a basic answer of the victim. The survivor is now, perpetrator is like the perpetrator playing the victim. The survivor says, I'm leaving the relationship. This is not healthy for me. And then we play the victim role. Like, what did I do to you? I saved you, and now you're trying to leave me. I deserve closure. I deserve these things because I am the victim here. And you're leaving me for no reason, right? You're leaving me for no reason. I did all these things for you. It exerts this level of guilt that can keep a survivor in the relationship as well.
Is it unusual for a victim of domestic violence to remain in a relationship with the abuser after the abuser physically assaults them?
It's not unusual. It's very common.
And why is it common?
So we go back to coercion, we go back to reconciliation. It wasn't that bad. You did this to me. We could make this work. Everyone has heard the term, this will never happen again, right? So it's a level of guilt that the survivor is hearing, or a level of happiness because, wow, they've told me that this won't happen again. This person is actually owning up to what they did, and now we can move forward in a relationship.
Same question. Is it unusual for a victim of domestic violence to remain after someone verbally abuses or verbally assaults them?
Yes, it is very common for someone to stay.
Is it for the same reason that you kind of just discussed?
Yes. Or even sometimes survivors blame themselves when it comes to verbal abuse or emotional abuse. Like, I deserve that. I really was acting that way.
Is it unusual for a victim of domestic violence not to pursue criminal charges in a case?
It's not unusual.
Ms. Hilton, are you done with that exhibit?
Oh, I'm sorry. Yes,
That's okay. If you could take down your screen share.
Yes. And is it unusual for a victim or for a survivor of domestic violence to withdraw or ask for a temporary protective order to be dismissed or withdrawn?
It's not unusual.
Why not?
I want to go back to the reconciliation, that when we're reconciling, right? So the survivor may believe the perpetrator has changed. This is not necessary. This is we're overdoing it, right? Yeah, I believe that this is way too much. Like, I believe that you're going to co-parent appropriately, and we don't need all these parameters. You could be coerced into that, or a survivor can say, well, we're always going to have they told me that we're always going to have a third party when exchanging children. We're always this person is not going to do these things alone with me anymore. So, of course, I don't need this level of protection anymore.
And I use the term a temporary protective order. Can you define what a temporary protective order is?
So in Georgia, a temporary protective order is that you can't be within X amount of feet of me. You cannot be alone with me. You cannot be within X amount of feet. You cannot contact me indirectly or directly. You cannot use family members, friends, siblings to send messages. This is a complete stop of communication.
And in Georgia, to get a temporary protective order, is that a civil hearing? Like, are both parties present when at a civil hearing to get a temporary protective order?
Yes. So you're going to have a plaintiff and defendant, but it's a civil proceeding. It does not turn criminal until that protection order is violated. But it's a civil proceeding. it is done in front of a, depending on the county, a family court judge, or done in the protective orders office, to have due process, because the defendant of that temporary protective order gets to deserve, constitutionally rights. They are able to do due process.
Now, earlier we talked about kind of isolation as it relates to the power and control wheel. Hypothetically, if an abuser or perpetrator moves a victim to a location where she's unfamiliar, has no friends or family, can that be a form of isolation?
Yes.
That was what she wanted out of this one.
How can that be a form of isolation?
So that can be a form of isolation because you are moving that survivor away from their support system. You are now around my family and friends, and they will be your influence at that time. So you have no immediate access to any support system when you're moved up and rooted from a place you know and are familiar with to somewhere that's new.
Hypothetically, if an abuser moves the victim to a neighborhood, or a perpetrator, moves a victim to a neighborhood for which he's familiar, he has friends, he has family in that neighborhood, he has neighbors in that neighborhood, and he never introduces his significant other to those individuals, can that be a form of isolation?
Yes.
How?
So that's a form of isolation where you are keeping the survivor in the home or away from the community so that the survivor cannot even create their own community, right? You typically when someone moves to a new community, you end up creating your own community, right? If you don't know anyone, you would be introduced as someone's spouse, and then typically in a healthy relationship, that spouse gets to navigate that neighborhood, join committees, or do whatever they need to do to feel comfortable.
Defense questioning of this witness could be pretty spicy.
We talked about isolation, and if an abuser, can an abuser isolate you, strike that. If an abuser isolates you from your children, can that be a form of control?
Yes.
Are there times when a perpetrator uses family members to kind of step into the place to exert power and control over a victim?
Yes.
How can that happen?
So specifically, if you're isolated to your partner's family members, they can use coercion as well. They can use the children. They can use these same tactics of emotional abuse and minimizing and threats to keep you in that abusive relationship. They're just doing it from the outside, but they can still be enablers. They can enable the perpetrator's behavior and use the same exact tactics that a perpetrator would use to keep you in that relationship.
In your experience, if a survivor is being abused and maybe her family members, family members maybe see signs of that abuse and they want to confront the abuser, and the survivor stops them from confronting the abuser. In your experience, what are some of the reasons that the survivor will not want a family member to, say, confront or approach an abuser?
Your Honor, I object to individual instances of her experience.
Sustained. You can rephrase if you'd like.
Sure. Hypothetically speaking, if a survivor...
Same question.
If a survivor does not want his or her family member to approach or to speak with an abuser, is that a form of self-protection?
Yes.
How?
So when we think about the dynamics of domestic violence, when we have outside family members approaching the perpetrator, the survivor is going to take the brunt of the blame for that family member or friend approaching and accusing or exposing domestic violence, right? Specifically if the survivor is still living in the home. So it is a form of protection. And it also can be a form of protection for the children.
Now, As it relates to this case, what, if any, information did you have as it relates to this particular case here?
I don't have any information. As an expert, I come in blindly because I'm here to stay within the psychoeducation and the science of domestic violence.
Let me ask you this. Did you know that this was a murder case?
Yes.
Did you read any police reports as it related to this case?
No.
Did you view any temporary protective orders as it relates to this case?
No.
Did you listen to any interviews as it relates to this case?
No.
Did you interview anyone as it relates to this case?
No.
Just trying to ask the questions defense would ask as soon as they stood up.
You spoke about earlier that you've been qualified as an expert in Georgia in about 47 cases. In those previous cases, have you had substantial information about those cases when you testified?
No.
Can you tell the jurors about being a kind of general expert? What does that mean?
So, a what?
A general expert.
General expert?
Objection.
I don't know what that means, Your Honor.
Sure.
I guess that's why she's asking the question.
Hey. Why is it that you choose to have minimal information about the case?
I have minimal information because as an expert, I am not here to diagnose domestic violence, and I'm not here to prove guilt or innocent. I am an expert. I'm a social scientist on intimate partner violence, and that's all I can offer the court.
Okay. Are you getting paid to testify today?
Yes.
How much are you being paid?
$250 per hour.
It's cheap. But for a lawyer who doesn't do any casework, that's pretty good. Or for a witness.
And was your testimony today based on your education experience working with domestic violence survivors?
Yes.
Course indulgence for a moment.
Sure.
Let's see if we get a break before defense questions.
Let me ask you this. Hypothetically, if a survivor gives full custody of her children to the perpetrator's mother, can that in some way be used to exert some form of power control over a perpetrator?
Your Honor,
over a survivor.
I'm sorry. I object to this kind of using evidence and posing it as a hypothetical to specifically ask her opinion of that specific conduct.
Understood. Overruled. Go ahead.
Do you need me to rephrase?
Yes.
Hypothetically, if a survivor gives full custody of her children to a perpetrator's mother, can that be used in some way to exert some form of power control over that survivor?
Yes.
How?
So if the perpetrator's parents now have the children, they have control of the children. They make choices for the children, and that leaves the survivor powerless in that situation unless the survivor navigates to comply with the current guardian's requests, the current guardian's recommendations. It could lead to an imbalance of power from that parent. So, yes, that can be definitely a form of exerting power and control.
Course indulgence.
Sure.
Careful. Thank you. No further questions.
If the survivor
Thank you.
Mr. Samuel, questions for this witness?
surrenders her kids to the...
I don't want to mess up my other ankle.
Allie B, thank you very much.
Good morning. Good afternoon, Ms. James.
Good afternoon.
Not doctor yet, right?
Almost.
Almost. When will you be doctor?
May of 2026.
Excellent. You and I have met only once before, right?
Yes.
A couple weeks ago. In this courtroom, right?
Yes, about a week ago.
I'm going to ask you some of the same questions as Ms. Hilton. First of all, you actually worked at the Fulton County DA's office for quite some time, right?
Yes.
How many years were you working there?
I started work in July of 2019, and I left in January of 2023.
Okay, so 4-ish years.
Yes.
Okay. And did you work with Ms. Hilton during that time?
Yes.
With Mr. Fawcett or Mr. Wilson?
No.
Okay. How many times have you worked with Ms. Hilton in a case?
So in the victim advocate role, we are assigned certain courtrooms. So I would only work with Ms. Simone if she was doing a case, if she was assigned to that courtroom or a case to that courtroom. And also she was the deputy, what we would call the deputy district attorney for the domestic violence unit. So she had minimal interaction with the bulk of the cases.
Asking you for a number somewhere between X and Y.
I don't really, I can't really define a number.
That's not a problem. How many times have you testified as an expert in one of her cases?
I believe once.
Okay. Of the 47 times that you testified in Georgia, were they always for Fulton County?
No.
Percentage-wise?
If we're looking at a percentage, most, I would say maybe 95%.
We're Fulton County.
We're Fulton County.
All right. So 95% of 47 would be, I don't know, 45, something like that?
But also one of those cases was with the defense.
Okay. So there was only one occasion where you ever testified for the defense?
In Fulton County.
Okay. And all the other times you were testifying either for Fulton County or, I don't know, DeKalb, Gwinnett, Cobb, somewhere? Correct?
Rephrase.
Well, I was just trying to do the arithmetic, but you said 47 times. One time you testified for the defense. The other, whatever, 44 or 45 times you testified for the prosecution. And almost all in Fulton County.
Yes.
Okay. And so you're being paid now to be an expert instead of being a member of their staff and just coming in and testifying. They, meaning the prosecutors. Now you went out on your own and you get to bill for your time, correct?
Yes.
Okay. And do you bill for all your time or just when you're sitting in the chair?
I bill for all my time.
Okay. So when we're late starting court in the morning and you have to sit out there, you bill $250 for that too?
Yes.
Okay. We'll have to remember that, Your Honor. Do you know how much you've been paid, how much you've billed in this case, or how much your hourly has been in this case so far?
Not yet.
Well, I know you haven't finished yet, but estimate the amount of hours you've put into preparing to testify in this case.
I would say estimate of 3 or 4.
Okay. And you met with Ms. Hilton, obviously, correct?
Yes.
She reviewed the questions she was going to ask you.
Yes.
She reviewed the hypotheticals she was going to ask you.
Yes.
She told you, I'm going to ask you in particular about isolation, and she said, I'm going to ask you in particular about the family, you know, having custody of the children, right?
Yes.
Okay. And you told her what your answers were going to be when she asked you those questions, right?
Yes.
Okay. Did she ask you any questions, I'm curious, in preparing that you said, no, I'm not going to be able to help you on that?
No.
Okay. So she would say, I'm going to ask you X and Y and Z and A and B, and you said, yeah, I can help you with all those things.
Yes.
Okay. I'm going to ask you a few different times and in a few different ways about your knowledge of the facts of this case. But before I do that, I'll probably end just like Ms. Hilton did with that. Your testimony, in essence, is an opinion based on a lot of experience in teaching and meeting with people and reading about the characteristics of abusive relationships, correct?
Yes.
Okay. you said, I wrote it down, that you can't put abusers in a box. I'm not talking about punishment, I'm talking about, one size fits all doesn't work, does it?
Yes.
That's correct, right?
Yes.
Okay, I asked a negative. That if you looked at did you say thousands maybe, or hundreds of abusive relationships you've looked at, more than just, a little bit, they're all different, right?
Yes.
Okay. Every relationship is unique, right?
Yes.
The abusers, and I'll just say the partners, whether they're gay, or lesbian, or trans, or male-female, or whatever, they can be wealthy and still have an abusive relationship.
Yes.
They can be poor, poverty-stricken, and still have an abusive relationship.
Yes.
There can be a family of history of abuse, a family history of abuse. In other words, generation to generation, correct?
Yes.
Sometimes you'll see partners for whom both sets of parents were in fact abusive, right?
Yes.
But sometimes you'll see partners for whom the parents, there's no evidence of any history of abuse in the generation above the one that you're looking at, right?
Yes.
Some parents, again, I'm talking parents of the partners, are abusive to each other, right?
Yes.
Some parents are abusive to their children, correct?
Yes.
Including the people you look at who then become the partners in the abusive relationship.
Rephrase.
Okay, I've got two generations here. I got the generation above the partners being, however you want to characterize them, whether man, woman, or whatever, abuser and what was the other word? Driver, you said? What was you said instead of victim, we call them?
Survivors.
Survivor, and so I'm looking at the generation above. Sometimes they're abusive to each other, right?
Yes.
And both the abuser and the survivor may think of their parents and think, this is normal. This is how I was brought up in my family. And justify it in their head, correct?
Yes.
And so what I was asking then was, is it sometimes the case that the parents of either the abuser or the survivor are abusive to that person?
Yes.
Okay. So abuse isn't always just limited to same generation, if you will.
No.
You can be abusive to your children, whether your children are adults or teenagers, or you can be abusive to your grandparents, right?
Yes.
Some parents spank their children, some parents don't spank their children, right?
Yes.
We wouldn't call that abuse unless it went overboard, correct?
I can't define that in this context.
Okay, not a problem.
Yeah.
I guess some parents are guilty of crimes, right? Parents of the partners you're looking at.
Yes.
You ever had a case, or do you have any experience in a case where the partners, the alleged abuser and the alleged survivor, the people you're looking at, that one of them is the child of a serial murderer?
No.
Would that be unusual?
I can't answer that in this context.
I'm sorry.
I can't answer that for you. I'm sorry.
Would that fit the dynamic that you're looking at, or would that be kind of outside the wheel and have to try to figure out what's going on there?
It sounds like out of the scope.
Yeah. Some people run away from home at a young age, teenagers, right?
Yes.
Some people marry at a very young age, 16, 17 years old, right?
Yes.
Okay. Some people don't. Some people get married late in life, right?
Yes.
Okay. Some people are suffering from PTSD, perhaps veterans, right?
In general, yes.
Okay.
It's a diagnosis.
Yeah. And PTSD can be caused by a variety of things, correct? Not just being in Afghanistan, but maybe from your upbringing, correct?
I'm hesitating to answer that because I don't practice. I don't do clinical practice in Georgia. I'm not licensed in Georgia to do clinical. I'm only licensed in Florida. That's why I'm hesitating to kind of answer that, because I don't want to be unethical in the state of Georgia when it comes to like diagnoses and mental health and a DSM-5.
Let me put you at ease a little bit. I'm not going to ask you for a diagnosis today. You're not going to be sued for malpractice for anything.
I don't want to.
Just in general, I'm not a doctor either. You know, PTSD can be the result of all kinds of different kinds of trauma, correct?
Yes.
Post-traumatic, right?
Yes.
It could be something that happened in your childhood. It could be something that happened when you were a teenager. It could be something that happened when you were in the military, right?
Yes.
All those things can create PTSD. Is PTSD something that you see in your experience being part of the dynamic, the wheel, if you will?
No.
Okay. You don't see people who are suffering from mental health problems?
So when we talk about the definition of domestic violence, we practice as it is a choice. I'm trying to make sure I stay ethical.
Yeah, sure.
We practice it as a choice, you know.
Okay.
Yeah.
I guess what I'm asking is, I apologize if my question was lousy, but either the abuser or the survivor might be suffering from mental health issues, correct?
Possibly.
Okay. If you look for the root cause of abuse, it might be, for example, infidelity.
The root cause, what we study is under the definition is exertion of power and control.
Well, that is the abuse. But the cause, if we treat it as something that's caused by something.
I'm not with him.
Either
she already says they treat it as a choice.
You're close to being a doctor. I'm nowhere close to being a doctor. Something causes either the person to be the abusive partner, and something causes the survivor to be susceptible to being. I'm not asking what abuse is. We'll get to that. I'm asking what causes it.
What causes is a choice. There's no diagnosis for domestic violence. There's no root causes of domestic violence. It is one individual making a choice that they believe is right to exert power and control over their partner.
Okay. Does the age and duration of the relationship have an impact on what would lead to abuse?
No.
There may be problems with alcohol.
Yes.
There may be problems with drug abuse.
Within the relationship, yes.
Huh?
Oh, within the relationship, yes.
Right. And there may be other, as I said, mental health issues involved that you have to deal with in the relationship.
Personally, each individual, they may have their own.
Right. You don't believe, and I think you said this to Ms. Hilton, that all abusive relationships are the same either.
Yes, each one is unique.
Right. Some may be more physically abusive, some may be more emotionally abusive.
Yes.
No expert would ever claim that all abusive relationships have the same characteristics or the same causes, correct?
Correct.
Right. Your wheel, for example, that we had on the screen for a while. Remember this?
Yes.
This is demonstrative exhibit 75. I don't think we need to put it on the screen again, but I bet you've memorized this, haven't you?
Yes, it's one of my tools. So.
Yeah. How often have you used this in court?
Many times.
Okay. The wheel, each of the pie pieces, right? The wheel looks like a pie, kind of, right?
The spokes? Yes.
Well, you call them spokes, but I'm looking at the triangles as pieces of pie. Maybe that's because I'm thinking of food. But
Sure.
And each of these pieces of pie have lists of examples of how intimidation is used, how emotional abuse is used, isolation, minimizing children, privilege, economic abuse. Did Ms. Hilton review this with you and say, let's see how many of these factors we can find in our case?
No.
Have you talked to her about it before?
I spoke with her about the power and control wheel, yes.
Okay. Did she talk to you about the fact that we are not involved in this case with ruining or destroying property? Are you aware of any evidence of that in this case, either through hypothetical questions or what you were told by the DA's office?
No, I'm not aware of any of that.
Anything to do with abusing pets?
I'm not aware of any.
Anything dealing with displaying weapons?
No.
Are you aware of any weapons in this case at all?
No, I'm not aware.
Okay. Are you aware of anything involving humiliation or playing games or anything like that?
No.
Are you aware of anything involving controlling what you do and what you read? Anything like that? Huh?
No.
Yeah. Are you aware of anything about joking about abuse? Do you know anything about that, or any hypotheticals asked you about that?
No, I don't know
anything about shifting blame onto you?
No.
Anything about making you feel guilty about your kids?
No.
You know how old the kids are in this case?
No.
You know how old they are? You talked about a hypothetical of placing kids with the supposed abuser's parents as being a sign of control. How about if the kids are like 6 months old and they're placed with the man's parents?
I have no knowledge of how old the kids are in this case.
Any evidence of using a 6-month-old or a 1-year-old to relay messages?
No.
Using visitation?
No.
I'm kind of going through your wheel, but you know that, right? Any evidence of treating the person like a servant?
No.
Being the one to define gender roles?
No.
Using race, culture, religion, or citizenship against one another?
No.
I'm eating unbuttered
Preventing
popcorn.
anybody from getting a job?
No.
Are you aware that Ms. Wolfenbarger was working at Waffle House?
No. I don't know.
You were asked about isolation. Would you describe isolation as having an outside job, having friends, having your sister working with you? Is that isolation?
Depending on depending on what the domestic violence looks like. Like I said, every relationship is unique. Isolation doesn't fit in a box where it has to be one thing.
Right, but if the point of isolation is to prevent you from having, recourse to friends or communities, I think you said committees or whatever it is, you have a sister, you have a job, you have co-workers, that's not isolation, is it?
It could be for some relationships. I don't know any examples of that.
Okay.
I haven't interviewed anyone in this case.
Yeah, the problem with hypotheticals is if you add a few more facts, they get more and more confusing, right?
No.
Well, I just gave you more facts dealing with isolation. You said, well, I just don't know about that.
It wasn't confusing. I said that I haven't interviewed anyone in the case. So I just can't speak to that.
Well, I'm not asking about your experience. I'm asking about your expertise. Would you describe that as being isolation?
It all depends on the nature of the relationship. Isolation isn't just one thing. I haven't interviewed anyone, so I can't answer that question.
Okay. The cycle of abuse, which is Exhibit 79, have you heard any evidence of a breakdown in communication? This is the tension building, number one. You heard any evidence about that, or any hypotheticals about that?
No.
Have you heard any evidence of blaming, threats, intimidation, number two?
No.
Number 3, abuser apologizes. Any evidence of that in this case that you know of?
No.
Gives excuses, blames the victim, denies abuse, anything like that?
No.
The 4th stage, calm. Any evidence of any of that in this case?
I don't have any evidence of this case. I haven't read any police reports. I haven't interviewed anyone. I'm not here for guilt or innocent. I'm just giving the science of what these tools mean and answering the hypotheticals as I'm asked.
Would you agree with me that many people who commit the crime of murder are not involved in an abusive relationship?
I can't answer that question because I don't know. I don't know.
You are aware from your experience that many people who are in an abusive relationship don't commit murder?
Yes.
I know you say you know none of the facts in this case, but you know some by virtue of the fact of the hypotheticals that Ms. Hilton said, these are the ones I'm going to use. Do these work? You know, can we use these, right? So you know from her preparing you that these are going to be the facts of the case. She wouldn't be asking you about something totally irrelevant, would she?
No.
Okay. Did you tell her to change any of the hypotheticals? To make them... Okay.
No.
Fine, good enough. I think you said you have no opinion whatsoever about this case, right?
I was called to do the science. I can't diagnose domestic violence. I can't do guilt or innocent. I'm not, I'm not a prosecutor or someone of the court.
I mean, I understand that, and I appreciate it. The point is that your testimony is just general observations about the way lots of different relationships that are bad exist, right?
No.
I use too many words that aren't appropriate, right? There are abusive relationships involving power and control. Your testimony focuses on that, but you don't know anything about this case, right?
No.
Correct?
Correct.
Okay. And as Ms. Hilton said, you haven't read a single police report, right?
No.
If I ask, it's the problem with a negative question. That's correct, right? You haven't read a police report?
No, I haven't read a police report.
All right.
This is his ending here. He's wrapping up.
These jurors have heard, I don't know, a dozen witnesses. You didn't hear any witnesses at all, correct?
No.
You've not talked to the detectives in this case?
No.
Or the medical examiners?
No.
Family members of the people involved?
No.
Either the defendant or Ms. Melissa Wolfenbarger, correct?
No, I'm not an investigator. No.
Right. You haven't talked to her. Have you learned anything about her parents and her family and her upbringing?
No.
Even from watching a little TV or learning a little bit about the case?
No.
No idea?
I have no idea.
Okay. All right. You haven't talked to me about this case, right?
No.
We had one brief court appearance together last week, but other than that, you and I don't know each other at all, right?
No.
Okay. Those are all the questions I had.
Ms. Hilton, anything else?
Yes.
Now, Mr. Samuel asked about different parts of the cycle of abuse. Could arguing be something that occurs in the tension building phase?
Yes.
Loud arguing, could that be something in the tension building phase?
Yes.
What about dragging of hair? Could that be something that be in the physical abuse or incident part of the cycle of abuse?
Yes.
What about dragging someone up the street? Could that be a part of the incident phase of cycle of abuse?
Yes.
Okay. What about markings on necks consistent with strangulation? Could that be evidence of an incident of abuse? Could a victim or survivor who drops a TPO after a private meeting with a perpetrator be examples of what can happen in the reconciliation phase?
Yes.
Can a survivor, who after meeting with her abuser privately decides to give full custody and control over her child, something that can happen in the reconciliation phase?
Yes.
And give full custody of her child to the abuser's mother. Could that be something that happens in the reconciliation phase?
Yes.
If a survivor after an alleged abusive incident, once she called the police, goes back to the abuser, could that be something that happens in the reconciliation phase?
Yes.
And are those some examples of what you've seen about how the cycle of abuse can occur in a domestic violence relationship?
Yes.
I have no further questions.
Thank you. Mr. Samuel?
No, thank you.
Okay. Thank you, ma'am. You may be excused. You can step down.
Thank you.
Okay, ladies and gentlemen, it's about 3:05. We're going to take an afternoon break, and probably 15 minutes, maybe 20. And we'll be back in here at 3:25. Realistically, it's going to be closer to 3:30. You know how that works. You've developed an understanding of court time now. Thank you for your understanding. We are in recess, and we'll get you back in here as quick as possible.
All right, while they go out on break, my daughter made me, I asked my wife for some lunch, but right after that, my daughter brought in a big bowl of unbuttered popcorn, which I believe is basically just healthy grain, right? Popcorn's healthy. No seasoning. It's just dry, air-popped popcorn. So I'm counting this as like diet food. Anyway. Yes, I do like buttered popcorn, but I probably shouldn't eat it.
Thank you all. You may be seated. Anything we need to put on the record regarding that witness or anything else before we adjourn?
No.
A break.
Can you put on the record at the bench conference where I asked for a...
Yes, thank you for the reminder, Mr. Samuel. After the witness, Ms. James, was called, the parties approached, and Mr. Samuel requested a limiting instruction on the basis of 404 regarding other instances that would form the basis of hypotheticals about which Ms. James would be asked. The court, I advised you, Mr. Samuel and Ms. Hilton, that my ruling had been that those prior incidents were intrinsic, and that my understanding of the law is that intrinsic evidence is admissible for any purpose, and therefore no limiting instruction was required or appropriate. So I did not give one. Separately, though, Mr. Samuel requested that the court give a limiting instruction regarding expert testimony. Although it is not something I typically do, the state did not object. And so I indicated that I would give that instruction, which I did after the state offered Ms. James as an expert, and Mr. Samuel elected to defer his examination and voir dire of that witness and her qualifications until after the direct examination. So I instructed the jury. Any objection to the charge that I gave the jury, Ms. Hilton?
None from the state, Your Honor.
Mr. Samuel?
No objection. But I also asked for a prior difficulties instruction.
Thank you. You are correct for clarifying that. You did, in fact, ask for a prior difficulties instruction. But as I said, my understanding is that because the evidence was intrinsic, it's admissible for any purpose and is not limited for as 404B or potentially prior difficulties evidence would be.
Understood.
Anything else?
No, from the station.
Okay. We're in recess for till about 3:30. Jeffy, where did that officer go?
All right, so we have a very little break, which should be about half an hour. We might have time to pop over to another court if something interesting is happening, which we'll take a look and see if there is something. Just wait. Still waiting on the Adelson case for the jury to be seated. I'm enjoying this popcorn. It's delicious. I think we're going to go, let's see what Judge Stephanie Boyd has going on right now. Let's see if this works. Oh, she's reading something. They're having a sidebar. I object to the lack of belt buckle. We are in Texas. Is a jury coming in? Does she have a trial going on right now?
All right, everyone can be seated. All right. So if this is about polygraphs and whether somebody passed a polygraph or didn't pass a polygraph, the court has already made its ruling. Nobody is allowed to mention the word polygraph. Now, what tools of investigation that people use? I don't know what tools of investigation he has used, but the defense is allowed to ask questions. And if the state's only objection is that this may leave a false impression with the jury or make the jury think that he's talking to a polygraph, then the objection will be overruled. He's allowed to ask questions about tools. Now, if there's another objection, the court will entertain it.
The specific objection, Your Honor, is he's asking about the result of the tools, and that result is inadmissible.
All right, with regards to the result of the tools, and I'm assuming this tool is the polygraph?
I think I asked for I didn't think I said result. I think I said findings. But
all right,
yes,
then that
I was
objection
following the instruction. The words I used were the specific words the court instructed me to use. I'm trying to follow the previous rulings and instructions of the court so I don't violate the court's previous rulings.
All right, then if you're seeking to obtain evidence from this witness, and you can call it tools, and that tool being a polygraph and somebody failed the polygraph, and that's what he's basing it on, then the state's objection is going to be sustained.
If I could refine, Your Honor, because
no, here's the thing. That's my ruling. If you are seeking to get information from this witness that someone took a polygraph, and we're calling it tools, and the results of that tool was that they were dishonest, then the court is not going to allow that. Does everyone understand? Do you understand my ruling?
I think so, ma'am.
All right. Let's bring the jurors back in.
All right, for the jury.
Polygraph not admissible in court, and calling it another name does not get you around that. It's a Dooney and Burke purse, pink tulips. Looks nice.
All right, everyone, you may be seated, and defense, you may proceed.
Did you find David Rocha to be honest or dishonest?
Dishonest.
Dishonest. In fact, your exact words in your report are, I can't rule him out as a suspect in the murder, correct?
Correct.
The video was on a flip phone. Is that what you were told?
That's what I was told. Yes.
And Frank, had a flip phone. You were also told that he even had a picture of Frank's flip phone, correct?
I don't remember that, sir.
Okay. Would it surprise you that you did? I know it was a long time ago.
Yes, sir, it was.
Okay. Now, they didn't ask you about it, but I will. At some point, you searched RC's apartment, did you not?
Yes.
Okay. And tell us about all the bloody clothes you found at RC's apartment.
I don't recall finding it.
Because you didn't, did you?
No.
Tell us about the blue denim purse you found at RC's apartment.
Didn't find it.
You didn't find it. Tell us about the stolen credit cards or pulse cards you found at RC's apartment.
Didn't find it.
Okay, now let's talk about the bloody clothes you found at David Roach's apartment.
David Roach.
Yeah, when you searched his apartment, he in your report, you can't rule him out as a suspect in the murder. So when you searched his apartment, let's talk about what you found there. You can look all you want. You never searched his apartment, did you?
Oh, okay. Yeah, I don't. Yeah, that's what I'm.
No. What about Frank? Let's talk about what you found at Frank Hernandez's apartment. He was also a suspect in the murder, was he not?
Yes, sir.
So let's talk about what you found at Frank's apartment.
Didn't search it.
Didn't search it. Barnett, he was a suspect in the murder, right?
I would say not really, but.
Not really?
No, but I didn't search his apartment.
Didn't search it. Antonio Jones, now you found out about him kind of late.
Yes, sir.
So wouldn't search that. Now, Antonio Jones is an interesting angle, if you will. Because Antonio Jones is tall, skinny, black guy, right?
Yeah, I would say that. Yeah.
Similar to the Scotty Perez, two tall, skinny, black guys. And Antonio Jones, when you tried to go talk to him at first, you went to his mother's house, Christina, right?
Yes. I think her last name was Guerrero.
It is.
Something like that.
And she was in her yard, I think, with her boyfriend Robert. Remember that?
Yes.
And they chased you off, right?
Correct.
Okay. Now, am I correct in remembering that your investigation led you to a conversation between Christina and Robert when Christina slapped Robert at a party and said, "Y'all filmed that"?
Yes.
Objection, hearsay.
You remember
Just one moment. Could you repeat the question, please?
Did your investigation lead you to an excited utterance between Christina and Robert when she slapped Robert and said, "You filmed that"?
And the objection.
And the answer was yes.
Hearsay.
No, excuse me. And what is your objection?
Hearsay, Your Honor.
All right, that will be sustained.
Excited utterance. That the court instruct the jury to disregard.
All right, ladies and gentlemen, you to disregard that last question and disregard the answer. Does everyone understand?
Yes.
All right, defense, you may proceed.
Where's Robert now?
Robert Cisneros?
Yeah.
I don't know, sir.
Dead. That surprise you? You don't know that? They didn't tell you that? He's dead. You know who killed him?
Objection, Your Honor.
Sustained.
What's his legal objection? One witness kills another, the jury has
the objection has been sustained.
Did we approach?
No.
Where's Antonio Jones now?
I don't know.
Objection, Your Honor.
Overruled.
Would it surprise you to know that Antonio Jones is in prison for murder of Robert? The guy that chased you out of his yard because he didn't want to talk about this murder got murdered.
It's spicy.
By a tall, skinny black guy. The same one that you tried. Did you talk? Remember the interview with him? And he was. How would you describe him in that interview?
Are you talking about Antonio Jones?
Yes, sir.
He appeared to be high.
High.
Yes.
Very. I mean, I think he was very high, wasn't he?
Yes, sir. He was high.
It was rough.
Mm-hmm.
Did you interview him again? Did you try?
I don't think I interviewed him again.
Okay. Let's talk about Robert Schultz.
Okay.
When did you talk to Robert Schultz?
I think that was a phone call only.
Phone call. And tell the jury what's the significance of Robert Schultz.
He called in one day and said that there was a gentleman named Cayman Reed who may have had checks from Miss Boyd's account.
Okay, I think we have our Robert Schultz is confused.
Okay, I'm not sure.
That's okay. The Robert Schultz I'm talking about is the guy that had a key to the apartment.
Oh, okay. You're talking about the
The
maintenance.
maintenance man.
Okay.
Yes, sir.
Okay.
And I believe his significance is important because you remember Officer Tapia, remember him? Is that the fellow that was the first guy at the scene?
I don't remember which officers were there.
Okay, would it surprise you that the jury heard from an officer named Tapia?
If you say so, sir.
Well, you went to the scene that day, right?
Yes.
Okay. And I know it was a long time ago, but I have reason to believe that the first officer there was Tapia.
Okay.
And he went into the scene first. And he has indicated, and I have reason to believe he spoke to a maintenance guy named Robert Schultz, right? And as lead investigator and someone who's handled over 150 murders, I would hope and I have every reason to believe and do believe that you reviewed his report as part of your investigation, correct?
Yes, sir.
Okay. And so I'm equally then in belief that you probably investigated Schultz because he told Tapia that he saw Ms. Boyd 9 o'clock in the morning the day before. That's the last time he saw her. But then the jury was told from Ms. Gracie from HEB that he told her he saw her that day.
Compound question.
Sustained.
I'll rephrase. Would it concern you when someone who has the key to the crime scene has given 2 different times when he last saw the victim alive?
That would concern me if I had noticed it, but I don't remember noticing that.
Does it concern you that I noticed it and you didn't?
No.
Okay. And
this one's spicy, guys.
And this is the same guy. Does it concern you now that this is the same guy that you let secure the scene that night?
No.
When he did secure, I'm just a regular guy and I watch TV like all of us. At least when you leave, do you put like some yellow tape over the door that says like crime scene or something? Or you just say, hey, Schultz, will you lock up when you leave?
No, there was no crime scene tape left.
Just, hey, Schultz, lock up when you leave.
No, I asked him to lock the door. I think he locked it in my presence.
You think?
Yeah.
Okay. But what happened between when you left and when you came back?
I received the results of the autopsy.
No, but at the apartment.
I don't know.
What officer stayed there to make sure the scene was secure?
No one.
You mentioned Cayman Reed. What's the significance of Cayman Reed?
Yeah, I received information that someone had seen him with a check that belonged to Miss Boyd.
Okay, may I approach, Judge?
Yes.
All right. So let's summarize what we have. Let's start with David Roach. You say he's a suspect, right?
Yes.
Okay. He's dishonest. My handwriting is terrible. You decided no search. Did you get his cell phone? Search his cell phone?
No.
Because you can track somebody's cell phones, right?
Yes.
Okay. Did you, earlier, you mentioned a guy and you said you ruled him out because you verified his alibi. Remember that?
Yeah, I ruled
okay. What about David Rocha? Did he have an alibi? And if so, did you check it out?
No, I don't. Well, Mr. Rocha was not interviewed until about 5 years after this murder happened. So I'm not sure if I would have been able to get his phone. Well, I didn't have his phone for one thing.
So he ran? He fled?
Yes.
Fled.
Mm-hmm.
I mean, is it because you didn't look for him, or you looked for him and he was gone?
I looked for him and he was gone.
Okay.
Yes, sir.
So that's David Rocha.
Mm-hmm.
Now let's talk about Frank Hernandez.
Yes, sir.
We'll be popping it back into the other court in just a couple minutes.
I want to make sure we summarize this as best I can, so I'm going to forget. Okay, first, Frank Hernandez. Did we search? Is he a suspect?
Yeah.
Okay. Now, you didn't have a chance ever to determine his honesty or dishonesty, did you?
No, he refused.
Because he refused,
he
right?
refused to provide a statement. Yes,
okay.
Sir.
Now, even when someone refuses, you can go to a magistrate and get a warrant and search his house.
Well, I didn't know where he lived. He lived with his mother at the time, as far as I know.
Okay. Well, you could have found her address and gotten the warrant, right? Did you do that?
No.
But there was no logical reason you didn't, right? You just didn't.
Correct? I didn't feel that I had probable cause.
But he's a suspect.
Yes, but I did not feel I had probable cause.
Did you get his cell phone records?
Yes.
Doesn't that require probable cause?
Yes.
Okay.
And
speaking of that,
if I can answer your question,
yes, sir. Go ahead.
I did not have probable cause to search his mother's house.
Where he lived?
As far as I know, that's where he lived.
Okay. His cell phone records, you did get, and you printed up. You provided these are from you, right?
Well, they're not from me. They're from
FBI.
FBI. Yes.
You got his cell phone records, and you had the FBI search where Frank's cell phone was, right?
Yes, sir. Correct.
And you blew them up giant, right?
Well, again, I didn't, sir.
The FBI did.
Yes.
Okay. And the significance of this is the crime scene is right here, right?
Yes, sir.
Okay. And so you got a warrant for his phone to show that when the murder happened, Frank's phone was there.
In the area. Yes.
Right. Okay. Mm-hmm. And it was significant enough that you printed up, the FBI printed up not one, not two, but 3 giant maps of Frank's cell phone, right?
Yes.
Okay.
We are going to go back to Georgia as soon as they come back. They're still on break. We won't miss a second of it, okay?
FBI phones.
We have sent flowers to
Let's
Judge
talk about
Boyd.
Antonio Jones.
Yes, we did.
Antonio Jones is the son of the couple you visited in the yard that refused to talk to you, right?
From what they told me, yes, sir.
You went to their house and they said, get out.
Yes.
Right?
Basically.
And Christina?
Yes.
And Robert?
Yes, sir.
Okay. So I'm going to write Mom, Christina, Dad. Oh, he wasn't Dad, he was boyfriend. Mom's boyfriend, Robert. They said, get out. Handwriting's getting worse. Without getting to what was said at the party, there was an altercation at a party between these two and the cell phone video. And now, in Indiana, Antonio Jones is in prison for murder.
Objection to narrative. Counselor Ness.
Is that correct?
Sustained.
Well, you answered earlier. Is that still correct?
You need to ask your next question, counsel.
Is that still correct?
Is what correct?
Antonio Jones is still in prison for murder of Robert.
Objection.
I only know that because
Excuse me. An objection has been made. Once an objection is made, I will hear what the objection is. I will make a ruling. If you're unsure whether to answer or not, then just ask me. What is your objection?
Outside witness already said he didn't know. It's been asked and answered.
All right, with regards to asked and answered, that will be sustained.
Yeah,
I'll move on.
May approach.
Yeah.
Okay.
What's the reason for approaching?
The witness said he didn't know. It's been asked and answered. The court sustained the objection. However, the demonstrative is intentionally left and is wrong.
All right.
Oh, okay. What is
just 1 second. So if you will
erase that part.
Counsel, if you'll remove the writing from the jurors until that is established.
Would it surprise you to learn?
All right. So counsel, if y'all remove that page.
I'll flip it, but
yes.
Would it surprise you to learn that Antonio Jones is in Indiana in prison for murder?
Objection, relevance.
That'll be overruled.
Okay, would it surprise you?
Yes. I know you know because we've talked about it at a prior hearing.
Yeah.
So you do know that, don't you?
Yeah. I mean, would it surprise
Yeah, flip
you?
it now. He does. He admitted he knows.
No. Could I have parties approach?
Judge Boyd's going to knock some heads together here. Wow. Okay. We don't need to record this one. Judge Boyd has this entire trial, which started yesterday on her channel. This is a great one to watch over the weekend, I think. Judge Boyd is one of our favorite judges down in San Antonio, Texas. Remember the Alamo. It's spicy. It's good. I'm almost finished with this popcorn. I had a whole bowl of unbuttered popcorn, which I believe is just healthy. It's like eating air is what it is. I want to see how this ends. We're just waiting just moments to go back to the other trial, which is already late. They were supposed to be back at 3:30. They're not.
May I continue, Judge?
Yes.
You do know that Antonio Jones is in prison for murder. Is that correct?
Because you told me, yes.
But in a prior hearing
yes.
on this event, you learned this, correct?
Yes.
Okay. I'm not making something up or speaking out of school. Correct?
No, you again, you guys told me.
Okay. Now back to Cayman Reed. What's the significance of Cayman Reed?
I received a phone call from a gentleman, and he said that he had seen Cayman Reed with a check from Miss Boyd's account.
So he had stolen checks, I guess?
Yes, sir, according to this person that called in.
Okay. Now, in contrast to those giant maps of Frank's phone, this was RC's phone, right? This little bitty map?
Yes.
And that he used and shows when he used his phone on those days, he was at Evers and 410?
Yeah.
Okay. There's a body on the card. What's the significance of that statement?
It means that someone was killed who owns that credit card.
In this case, what's the significance of that statement? If you remember from your
when someone says there's a body on whatever, they're talking about someone being killed about that particular item.
It was said in this case, so in your 150 cases of experience, do you remember in this case who said it?
No.
Okay.
All right, we're about to jump back to Georgia. I can see in the reflection of the clock some motion in the court, so we're just waiting. I've got audio turned on from Georgia. As soon as we get audio, we're going to jump back. But this is spicy. This is live right now out of San Antonio, Texas. Judge Boyd doing what she does.
Did you
surf the web.
or someone else in police jargon, canvass the neighborhood. And when I say canvass the neighborhood, to me, that means have some either uniforms or detectives go out and interview all the neighbors. Did somebody do that in this case?
We knocked on a few doors, yes.
A few doors.
Yes.
What does a few mean? So how, in this case, how many, what does that mean?
2 or 3, and my main focus on canvassing was for video surveillance.
You asked 2 or 3 people in an apartment complex of 300 and, I forgot, 305 units? More or less 300 units. You talked to 2 or 3.
Yes.
Okay, who talked to those 2 or 3 people? You or somebody else?
It wasn't me, no.
It wasn't you. In your 150 murder cases of experience, is that typical? You talk to 1% of the occupants to see if they saw anything?
It all is case specific.
But in a would you agree with me that maybe somebody should have talked to more people than that?
Oh, I won't agree with that. No.
You won't agree with that?
No.
Okay. What about getting DNA from the guy that had a key?
No, I did not.
I'm sorry. What about searching his house or apartment?
Did not.
Okay.
All right, that seems like a good enough time to make the switch. I've just posted in chat a link to Judge Boyd's channel. Those videos, she doesn't delete them. They'll stay up. You've got a couple days worth of videos to watch there on this trial if you want to go back and watch the whole thing. So there's no need to jump out right now, but it's fiery. It's fiery. All right, let's see. We love Judge Boyd. She's phenomenal. We did, in fact, at one point send her flowers. Chat decided, this is what happened. Chat decided to send her flowers and then started making donations to pay for the flowers. Before, like I don't think I'd even mentioned anything. And once the donations come in and the donations were for that, I couldn't say no. I mean, like, no, I'll keep it. No, I can't. It was given for that purpose. So we found the display of flowers, the bouquet that the closest matched the amount of money that was given and had it delivered. It was delivered actually on a live stream. So the delivery guy came in and she's like, oh, just have him put them right. And that was it. So did have a little card thanking her from all of us, but it was funny. Amber, there's another Georgia case. Holy cow. We got a few happening. Which one did you... Oh, that one. Okay, I looked at that one. She's a huge LSU fan. She's also a huge HEB fan. Chad is the boss. No, not the boss, but when it comes to people donating money, I want to be above board on everything. So, all right. Any second now, we expect to start back in this trial. We're late. She said we were going to be back at 3:25, and they said it's probably going to be 3:30. It's now almost 3:40, and yeah. Love spicy Judge Boyd. She does not like getting pushed around by lawyers, and that defense attorney trying to bully her into responding a certain way to an objection. She does not take well to that. Did you start the flowers to the judge friend? No, she's been getting flowers mostly from her mom for a long time. Sometimes she buys them for herself, but she does get some, especially around her birthday and stuff. She gets a lot of flowers delivered to her. She's a movie buff with a steel trap mind. I think she has a book club as well. She's great. What I like about her most is that she really does have the best interest of the defendant in mind, and she is sometimes she's very stern, and sometimes she's very caring and motherly. But she wants people to be good parents, And the number of people she has sent to parenting classes probably exceeds any other judge as far as that goes. Sent flowers to my wife at work. All the ladies were so jealous. That's one of the reasons you do it. So she also teaches courses. She's quite down to earth. The purses are mostly gifts from her mom. Okay. Don't make me regret skipping out on Judge Boyd's court here. They're supposed to start. I saw a bunch of movement on the clock, just the reflection of people walking back and forth. Thought for sure it was the defendant coming in from the side room. How do we get into her book club? I have a book club, but there's only me in it. So, like her and Judge Simpson and Fletcher. Oh, man. Fleischer is amazing. It took a while for him to grow on me. The first time I saw him, I was really put off. But I have heard we're looking at tomorrow afternoon start for the Adelson case. Are we just on a break? We are. It was a short break that became a long break. It's almost been 40 minutes now. But the jury came in at lunchtime, so, you probably should have eaten before you arrived. Everything's fine. Misconduct, I think he did it, but where's the evidence? That's what the jury needs to determine. With the domestic violence expert, this is good information, and I believe it's also very accurate information. My concern with it being brought in is that it is quite prejudicial. And I say that because I sit here and I'm watching chat, okay? And we can talk about statistics forever and basically the statistics of how many people have experienced domestic violence of one sort or another are shockingly high, just incredibly high. And it's quite, it is quite triggering for a lot of people who are survivors of that. That's what concerns me about the jury. If the jury's getting triggered, and I realize they probably went through voir dire and were asked questions about this, but if you're bringing up that same experience and you're recounting all the different ways that the domestic abuse can occur, is that fair to the defense? When there is the only testimony of domestic abuse has come from two people who have been trying to, a couple people have been trying to get the defendant arrested or in jail for years, like starting when he was 15. Yeah, I don't know. We are close to 1,000 likes. We're missing 105 off of the like button. So if I test DNA now, there would only be 895 of you contributing to the DNA profile on the like button. So if we can add that number and really obscure the DNA, that would be great. The only flowers I get are the ones I buy myself or my parents get for me on special occasions. I need to get Mrs. R.A. flowers more. She deserves flowers. I'm trying to think when we can have them delivered for best effect. Yeah, I've got to do some research. I don't even know where the nearest florist is. When is the Wendy Adelson trial going on? See, the question there, Jamie, is quite interesting. Wendy has not been charged yet. It's anticipated, or I would say this, some people have speculated that Wendy will be charged with connection to this whole event after this trial's over. Remember how Charlie's trial came first and then Donna got charged? It might be like that. But Wendy is a witness. Oh, she is charged. She hasn't been tried yet. Is that the right thing? I have to think. I don't know if she's charged or hasn't been charged or hasn't been tried. I know she hasn't been tried because she got a use immunity. I have to rethink that one. Wendy has immunity for testifying, but only for the prosecution. Like testifying for the prosecution. If she were to testify for the defense, she would not have immunity, and because of that, she's going to invoke her fifth on that one. Finally, we're back.
Madam Court Reporter, are you ready? Okay, we're going to go back on the record after our afternoon break. Is the state ready?
State's ready.
Is the defense ready?
Ready, Your Honor.
Do we have our witness?
Yes. I think she's right.
Okay. I don't know what happens when people go outside. It's like they just disappear or something when they leave the courtroom. Okay, I think we're ready for the jury.
Alien abduction. They disappeared. Big sigh from the judge. And a sniff. Just gonna Google florists near me. I know there's a couple because we've got 2 funeral homes in my town. Ava's Flowers. You're right. Apple Treasure offers same-day flower delivery from 8 to 6. Don't think I can count this as a business expense, though. 2 funeral homes in case one goes under. Yes.
Jurors are present and counted.
Thank you all. Please be seated. State may call its next witness.
Your Honor, the state calls Dr. Carol Terry.
Dr. Carol Terry. We've got to be close to being done with this trial. I believe he got injured somehow. I've read everything from climbing accident to train wreck. It's not part of his case.
Please. And when you reach the witness stand, if you'll do me a favor before you have a seat, turn and face the deputy and raise your right hand. He'll swear you in, okay? Okay.
Now, when you raise your hand, please, you solemnly swear to testimony about the portion.
This is probably true.
I do.
Tammy knows.
Take a seat. State and spell your name for the record, please.
Dr. Carol, C-A-R-O-L, Terry, T-E-R-R-Y.
Dr. Terry, good afternoon.
Good afternoon.
Can you tell the court where you're currently employed?
Well, I am currently employed as the Chief Medical Examiner for Gwinnett County.
Okay. And what are your duties as a Chief Medical Examiner?
Well, I am a forensic pathologist, and my duties involve investigating deaths that are reportable to my office under the Georgia Death Investigation Act. So these are deaths that are sudden, unexpected, unexplained, or due to non-natural causes. And as the medical examiner, my duties involve determining cause and manner of death. Cause of death is what it sounds like, what caused the person to die at this point in time. Manner of death is a way in which we categorize deaths for purposes of reporting on the death certificate.
Okay. And where did you work prior to being employed at Gwinnett County?
Prior to coming to work at Gwinnett County, I worked as an independent contractor for Dr. Gerald T. Gawitt, and that's G-O-W-I-T-T, who is the Chief Medical Examiner for DeKalb County. And not only did we handle cases for DeKalb County, but we also covered medical examiner cases for Hall, Henry, Rockdale, and White counties.
Okay. And prior to that, where did you work?
Prior to that, I worked at the Fulton County Medical Examiner's Office as an associate medical examiner.
Okay. And are you licensed to practice medicine in the state of Georgia?
Yes, I am.
Okay. And when did you become licensed?
1992.
Can you go over for the jury your education and training?
Yes, I can. In 1986, I graduated from Emory College of Emory University in 3 years with a double major. I have a Bachelor of Arts in Religion and a Bachelor of Science in Biology. From 1986 to 1990, I attended Emory University School of Medicine, where I received my Doctor of Medicine degree.
Hang on, I'm so sorry to interrupt you. I'm just going to ask if you'd slow down a little bit.
Okay.
I want to make sure the court reporter can keep up, and you're a little bit of a fast talker.
Oh, sorry.
Thank you. That's okay. Please go ahead.
Thank you. So I am a medical doctor. From 1990 to 1995, I did a residency in pathology in the Emory University affiliated hospital system. Pathology, broadly stated, is the study of disease, and my 5-year residency involved a combined program of anatomic and clinical pathology. Anatomic pathology is tissue-based pathology and involves diagnosing disease states from tissues, such as biopsies, organs, or tissues removed from living people, as well as autopsy specimens. Clinical pathology is the laboratory medicine aspect of pathology and involves such areas as chemistry, hematology, microbiology, and blood banking. During the last year of my 5-year residency, I was allowed to work exclusively at the Fulton County Medical Examiner's Office in a subspecialty of pathology, forensic pathology. And forensic pathology is the medical legal investigation of death. So, after the completion of my residency in 1995, I did an additional year of study in forensic pathology, also at the Fulton County Medical Examiner's Office. And this year of training outside of the residency was referred to as a fellowship year. And I did my fellowship year at the Fulton County Medical Examiner's Office in forensic pathology from 1995 to 1996. But because I already had a year of experience in that office, I was essentially treated like a junior attending and got to supervise other individuals in training as they rotated through the office. Following the completion of my fellowship in 1996, I stayed on staff at the Fulton County Medical Examiner's Office as an associate medical examiner. And that's where we picked up. I worked at the Fulton County Medical Examiner's Office from 1996 to 2004. 2004, I went to work for Dr. Gowett in DeKalb as an independent contractor and worked for him until the beginning of 2006. In February of 2006, I was awarded the medical examiner contract in Gwinnett County and took over doing the medical examiner duties for Gwinnett County. In Gwinnett County, the medical examiner position is not a county department, it is a contracted position. And my contract comes up for renewal every 5 years, where I have to rebid for the contract. And as I said, I was awarded that in February of 2006 and have maintained it to the current time. As we said, I'm licensed to practice medicine in the state of Georgia and have been since 1992. I am triple board certified by the American Board of Pathology in all 3 areas of pathology in which I have trained and studied: anatomic, clinical, and forensic pathology. I have personally performed between 6,800 and 6,900 autopsies. I've supervised individuals in training in approximately 700 additional cases. In my career, I have examined over 10,000 bodies because not everybody gets an autopsy. There's some bodies that I just do an external examination on and maybe draw specimens from to do additional testing, such as drug screen or other types of laboratory tests. And I have been tendered as an expert witness in the Superior Courts of Georgia over 455 times.
Your Honor, this time the state moved to tender Dr. Carol Terry as an expert in forensic pathology.
I am afraid to object, Your Honor.
Go ahead.
That was funny.
Now, can you tell the jury what an autopsy is?
Okay. An autopsy is a medical procedure by which a body is examined, both externally or from the outside as well as internally, looking at the organs to evaluate extent of disease and or injury.
And who or what factors determine whether or not an autopsy is performed?
Well, as I said, for us as medical examiners, it's dictated by state law, which cases are reported to the medical examiner's office. And again, these are deaths that are sudden, unexpected, unexplained, or due to non-natural causes. And then once it's reported to the medical examiner's office, it is left up to the discretion of the medical examiner what type of an examination is conducted, again, with the goal to determine a cause and manner of death for purposes of reporting on the death certificate.
Okay. And the procedures that you've testified to, are they generally accepted in the medical community?
Yes.
And you tell the jury, you're familiar with Dr. Joseph Parker?
John?
John Parker, excuse me.
Yes, I am.
And who is Dr. John Parker?
Dr. Parker was a mentor of mine. He worked at the Fulton County Medical Examiner's Office and also in Bibb County as the medical examiner in that area. He was responsible for some of my training. And ultimately, when I went to DeKalb County to work for Dr. Gowett, it was because Dr. Parker had stepped down from that position. Dr. Parker, I worked with him in the Fulton County Medical Examiner's Office when I came on staff there. I think and thought the world of Dr. Parker. He passed away in 2012.
Okay. And was he the medical examiner that was, I guess, the head medical examiner that examined the remains of Melissa Wolfenbarger when they first came in?
Yes, he was the medical examiner who was on duty the day that the remains of Miss Wolfenbarger were discovered.
Okay. And at any point, did you assist in any type of investigation or analysis as it relates to the remains of Melissa Wolfenbarger?
Yes, I did.
Okay. And what period of time are we talking about where you would have been involved in any type of analysis regarding those remains?
My first direct interaction with the remains occurred in February of 2000 when I was turning over the skull along with some other skulls to the state's forensic artist, Marla Lawson, to do some facial reconstructions. I had a case of mine from 1998 that I wanted her to do a facial reconstruction on, and she had recently completed some training. Her skills as a forensic artist were legendary in the police department, but she had adopted or had taken on some new training in doing facial reconstructions off of the skulls using clay or paper mache. And so that's when I made her acquaintance in February of 2000. She came to my office to get the skull of the case I was handling, but she said, if you have any others that you want reconstructions on, she said, I'll bring a U-Haul if I have to, give me all that you have. And she, was taking on that work, and I had amassed the reports associated with these different cases, as well as investigation summaries, and was turning them over to her. And when she looked at this particular skull, she raised the question of the sex of the skull, because it was indicated to be a white male. And Marla, if you knew her, she was very modest, even though exquisitely talented, and said, this looks like a female to me.
Hearsay. All right.
Sustained.
All right. Let me ask you this. At that time in Fulton County, were you working with investigator Tina Miller?
She was a detective with the Atlanta Police Department, yes.
Okay. Did she also assist the Fulton County Medical Examiner's Office with investigations related to missing persons and or death investigations?
Not death investigations, missing persons and unidentified remains.
Okay. Were you aware whether or not Detective Miller went out to that location where Melissa Wolfenbarger's remains were located at any point during the investigation?
Yes, she did.
Okay. And you're familiar with the location being Avon Avenue in Atlanta, Georgia?
Yes, I am.
And is that in Fulton County?
Yes, it is.
Tell the jury what happens when, say, a body or remains come into the medical examiner's office.
Well, when the body comes into the medical examiner's office, the medical examiner on duty determines what kind of examination is going to be conducted on the remains, and then depending upon the case, that dictates what is done. Most of the time, the bodies are intact, and again, they may get what's called an external examination, just an outside viewing of the body and drawing of specimens for additional testing, or they may get an autopsy where the body is opened. And there may be a complete autopsy. In Fulton County at that time, we did not do limited dissections. We only did complete autopsies. So if an autopsy is done, it involves opening up the body and examining and removing the brain as well as the organs of the chest and abdomen and pelvis. And in the course of the examination, specimens are collected for potential additional testing. Again, it depends upon the nature of the case.
Okay. And any observations, conclusions, are they documented in any form during that process of performing the autopsy?
Yes. Typically, the examinations are documented with written notes and or dictations that are then converted into a final report.
Okay. And is there other forms of documenting the process of the autopsy itself?
Yes, also photographs are taken typically in the course of the examination.
Okay. At the conclusion of the autopsy, is there a process for reviewing or discussing observations that are made during the autopsy?
I don't know necessarily if at the conclusion of the examination, but in the Fulton County office, as we were associated with the training program through Emory, we routinely had teaching conferences and conferences where we would sit and review all of the slides that were taken, because at that point in time, things were done with 35 millimeter and slides were created. And every week we would have one or two conferences where we would go through all of the slides.
Okay. Now, in preparation for your testimony today, did you review any documents and or photographs associated with the autopsy of Melissa Wolfenbarger?
Yes, I did.
And what did you review?
Well, I reviewed, it turns out I had case notes that I had collected back at the time when I did this, when I was doing this review of the case, because I was very much interested in trying to identify remains. So I had copies of notes from the file, including some of the notes that I had made documenting some of the actions I had taken to try to get the remains identified. I also reviewed Dr. Parker's report. I reviewed any investigative reports that were in the file, as well as any photographs that were provided to me, because I did not have actual photographs from the examination.
Okay. And at any point during your work that you did associated with this case in particular, did you have an opportunity to either view any of the remains of Melissa Wolfenbarger? And you could describe that for the jury.
Yes, I did.
And when did you do that?
Well, in February of 2000, when I was turning the skull over to Marla, that was my first time that I had an opportunity to look at the skull.
Oh, okay.
And I looked at the skull.
All right. And discuss any other opportunities that you've had to look at the remains of Melissa Wolfenbarger.
And after she was identified, I had the opportunity to go and retrieve some of the specimens that had been collected to follow up on requests made by the Atlanta Police Department's Detective Calhoun to submit specimens to the Georgia Bureau of Investigation, specifically for some drug testing.
Okay. And when you say specimens, are you referring to the extremities of remains that were located?
It was some soft tissue from the extremities, yes.
Okay. All right. Now, what, in terms of, initially, I believe your testimony that there was a process of conducting an identification. What did you do to identify the remains?
Okay. And then two, I've also neglected to mention, also in the course of doing this, there were times when I went back to the remains, specifically the skull, to extract teeth or to take additional bone to submit for potential DNA analysis. So that was something else I also undertook with the knowledge of Dr. Parker to try to facilitate the identification. So what else I did in addition to collecting and submitting specimens for DNA analysis was, again, just became aware of features associated with the skull. For example, I did not need my records to refresh my memory that the skull had one filling in tooth number 31. That's something I've remembered all these years. There was one filling in that tooth. And that was something I was aware of as I was checking records, and any cases came to my attention. Also, at this point in time when I was in Fulton County, I did have an interest in trying to identify unidentified remains. And I had a computer program where I took missing persons reports and locations of where people went missing and plotted them on this map along with where we had unidentified remains, trying to look and see if there's any kind of spatial relationship between where people had gone missing and where remains were found. So this is something is just about being aware of who's missing and who we have who are unidentified in our morgue.
She had Google Earth.
Some people have various other research interests. This was something I was very much interested in because as a forensic pathologist, one of our big goals is to answer questions. And to me, there's no bigger question than who somebody is. And that was something that was of interest to me. And so I was happy to do whatever I could to try to facilitate the identification in this case. And especially since Dr. Parker was kind of part-time with our office, so he wasn't always there. But this was something that was always on my mind.
Okay. And what was the process for identifying the skull that was retrieved in April of 1999?
Haven't delivered on
Or
Friday.
how the skull came to be identified?
That's correct, yes.
Okay. Because we had made attempts to have DNA pulled from the skull from the teeth.
Objection. Can we approach?
Sure.
I'm going for a Friday delivery because Mrs. R.A. and the kids will be on a field trip tomorrow. An adventure field trip, which is just crazy. High in the treetops in a really cool place. So she'll be gone tomorrow. I can't get them delivered today because it's already 4 o'clock. Nobody can get them done that quickly. So Friday it is. Shh, don't say anything. It's quiet. It's a secret. The event is just because, and the note says, for the best homeschool teacher I know, because school year starts on Monday, and why not give her flowers to kick off a new school year? So I have to be quiet. She's reading in the other room, and the door's open. That's why I'm quiet. I don't want her to hear. So it'll be a surprise. Plus, I just got a delivery, and so she should get a delivery. That's how it works. Slot Life, thank you very much. Putting up with RA. That's probably more realistic. Our lips are sealed. Thank you. Rebecca, thank you very much. Appreciate it. All right. Waiting for this. I love this ME. She is super, super experienced. She knows all the questions. She answered all her background questions in one go. So, Trey, thank you. I think we're good, guys. Thank you very much. We're fine on the fund. If I don't want to have to call back and have to, up the order because I feel guilty. Reason RA is guilty. There's the reason. Oh. Did she say she's only triple board certified? No, she's pretty much done everything. Tammy E, thank you so much, Tammy. Appreciate it. Hey, friends, on my phone at the moment, so tagging is a pain. Hope everyone's doing
well.
And
as far as the was the Fulton County Medical Examiner's Office able to retrieve any dental records associated with this case itself?
Voir dire?
Yes.
All right. Did you have an opportunity to review those records along with Dr. Hoptel?
Yes.
And was that the basis for the determination of the identification of the skull?
Yes.
Okay.
Ellie Veldman, thank you very much. 5 gifted memberships. DSN, thanks for adding to the jar.
All right. Now, I'm going to hand you.
Jade, thank you. You guys are amazing. My wife's super amazing, but you guys are really, really cool as well. So thank you.
Your Honor, with the court's permission, I'm going to hand Dr. Terry the following exhibits. I'm going to read into the record.
Yes, sir.
Exhibits 34, 36, Exhibits 40 through 49, Exhibits 51 through 52, Exhibit 54, Exhibit 56 through 57, and Exhibits 60 through 61.
That's a lot of exhibits. The witness table is getting quite exhibity.
Terry, I'm going to hand you.
Hang on just one second. Can you come here, please?
Terry. He says, Terry, the judge says, hang on. I don't think she's objecting to the, you don't call them by their first name in my courtroom, no matter how well you know them. Weather Watch, yes, thank you very much. By the way, since we have a break right now, tomorrow is podcast day, and I think we're going to have some fun stories tomorrow. So,
go ahead, Mr. Plessette.
8 p.m. It's going to be great. Eastern. It's a whole manila file full of records. For the Greeners Fund gift train. Oh, that fund. All right. We'll go make sure this goes over to it. Thank you, Greeners. I thought it was Terry Carroll. It was Carol Terry? Okay. Oh, I should probably look at my own pinned comment. So Terry is appropriate. It's just informal. It's just last name. Greeners was not only giving himself a donation, he was requesting a fund train of donations to the same cause. See, so EDB uses exhibity as a noun. I used it as an adjective. Whiskbrand, I do have PayPal. I think we can put a link in chat if you would like to do something that way. I beat Amber by a split second. So just wait for the reply, and I think that'll give you my PayPal. There it is. Right there. Thank you, my friend. Appreciate that.
Okay.
Okay. And after viewing those photographs, do you recognize those images as being associated with the remains of Melissa Wolfenbarger?
Yes, I do.
Do you recognize those images as being associated with the same remains that you viewed at the Fulton County Medical Examiner's Office in 2000?
Well, this doesn't specifically show the skull. Those are the remains I remember actually seeing, but I am certainly familiar with the photographs.
Okay. And are they a fair and accurate representation of what you recall observing?
Yes.
Your Honor, this time the state will move to tender into evidence. States Exhibit 34, 36, 40 through 49, 51, 52, 54, 56 through 57, and 60 through 61.
Mr. McDermott?
No objection.
Okay. They are admitted.
Thank you, Super T. Thank you, all of you. You're amazing.
Was your recollection of, after reviewing the documents as to when each of the the skull and the extremities were located?
Well, the skull was located on April 29th of 1999, and the extremities were located June, let me double check here, I can't remember, the 2nd or 3rd, also of 1999. So let me find this. June 3rd, 1999.
Okay.
I think only mods can trigger the different payment methods. So like Cash App.
Mr. Fawcett?
Yes.
Are you preparing to publish those photographs?
No, I'm not.
Okay, just
No, I'm not.
making sure we have a heads up before we do.
Absolutely, Judge. I am publishing State's Exhibit 2. So I want to turn your attention to this State's Exhibit.
There it is.
Is that area in itself familiar to you?
Just by virtue of the names, I don't recall ever having been out there myself.
Okay. And you recognize that as being the location where the skull and the extremities of Melissa Wolfenbarger were
I won't
located?
object, Your Honor. She says she doesn't have any knowledge, personal knowledge in this area.
I'm not sure that's exactly what she said, but overruled. Go ahead.
All right. You recognize that location, the street itself, as being the location where the remains, the skull, and the extremities of Melissa Wolfenbarger were located?
Yes, as I said, I'm familiar with the names, but I can't say that I directly went to that location, but I in my mind, had the skull associated with Avon Avenue.
Okay. And looking at that photograph, based on your review of your notes and your recollection, the image depicted in State's Exhibit 2, is that generally the close proximity in which the remains, extremities, and the skull were located?
Yes, that is my understanding.
I do plan on publishing photographs at this point, Judge.
Okay. So, ladies and gentlemen, I told you that I would give you a heads up so you could sort of prepare yourselves that we probably the next series of photographs are going to be somewhat graphic. Now, for those of you who are in the gallery, I encourage you, if it's not something that you want to see, to make arrangements so that you don't have to see it. Go ahead, Mr. Fawcett.
Yes.
Judge says content warning. Thank you for that.
Now, Dr. Terry, you were testifying as to your, I guess, ability to review and examine the skull of Melissa Wolfenbarger?
Yes.
Okay. And I'm publishing State's Exhibit 16. And just, could you describe the state of the skull that it was in when you viewed it?
She can't see it.
All right, in this photograph, this is a decomposing head that was in the roadway. This is the head that I saw the skull from when I mentioned that I was turning the skull over for reconstruction purposes. But again, this is a photograph I'm familiar with as it pertains to the day that the head was found in the road there at Avon Avenue on April 29th, 1999.
Okay. And after viewing the skull, were you able to determine if there was any damage to it?
Yes, there was damage to the skull.
And what type of damage are you referring to?
On the left side of the skull, there were some fractures, and there was some bone in the roadway that were described in the report, as well as in an adjacent plastic bag. It appeared that the skull had been struck by a vehicle in the roadway.
Okay. And what does post-mortem mean?
Post-mortem means after death.
And is there a distinction between injuries you would, I guess, damage to flesh or bone? Is there a difference between, I guess, pre and post-mortem?
Or ante-mortem, post-mortem, yes. Before death versus after death, yes, there's a difference.
And what is it? What differences would you observe?
Well, typically differences that you see in antemortem injuries, the person's alive, so they still have a blood pressure, there's blood flow, and so when an individual is injured antemortem or before death, you have bleeding that's associated with injury. Postmortem or after death, there's no longer blood flow, and these injuries don't bleed.
I'm now going to show you what's been admitted at State's Exhibit 36. Can you tell the jury what we're looking at?
Okay, yes, this is one of the vertebrae that was associated with the head that was, or the decomposing head that was found in the road on Avon. And this is one side of this. It's a cervical vertebra, or a bone that's from the neck area. And you can tell because, can I touch the screen?
You can. You can enable that function, and you can actually tap on it, and draw on it in colors.
Okay, let's see.
There's a button. I think it's off to the left on the bottom of the screen.
Oh, okay. These structures here in this vertebra identify this as being a cervical vertebra or a bone from the spine in the area of the neck. And as we look at surfaces here of the bone, specifically those are articular surfaces where the bone would interface with adjacent vertebrae or bone. So in looking at this surface of as well as in this area here, this is where the bone would articulate or interface with the adjacent bone of the spine. And based on the review of the report as described by Dr. Parker, this would be the third cervical vertebra. So 3 down from the base of the skull.
I got it, Jan. Thank you so much. That is super generous.
I'm going to show you State's Exhibit 37. I can offer no assistance with getting the marks off the screen, though.
I think there's a clear button on the maybe bottom right.
There's something that says leave.
I don't think I want you to leave.
Oh.
No, ma'am.
Nope, sorry.
Wait, I already pushed it.
Go ahead. Yes.
Miss Hilton's going to come up and push the buttons, clear the screen. You should have thought of that before you colored on the monitor, ma'am.
Okay, all right. Okay, so this is the flip surface of that vertebra. And in looking at this surface here, specifically, can we bring that function back up? Okay.
Oh man, I had just seen the last post from him in a hospital bed. Knew he was fighting something, but didn't
Specifically,
know he passed
these areas all appear to be kind of shaved off to the same level. And again, this is the reverse surface of that vertebra.
Thank you.
Now, when you are performing autopsies or working at the medical examiner's office, do you often use instruments to assist with that?
Yes, I do.
And what types of instruments do you use to, say, cut through bone or hard materials while you're working?
Typically, I use an oscillating or striker saw where I have a blade that will either spin or go back and forth to cut through bone. Another tool that I commonly use to cut through bone are basically like loppers, kind of garden shear type things used to cut like small tree branches, and we'll use those on ribs to remove the chest plate. Typically, we'll use the striker saw or the oscillating saw to open the head and to take sections of bone.
They use limb pruners on ribs? Did you just head down to the garden store and get yourself
Now,
some rib cutters?
Did you also, were there also photographs of Ms. Wolfenbarger's extremities included in the photographs itself?
Yes.
Right. And did those extremities have flesh on them?
Yes, they did.
Okay. And let me ask you this. Do you recall, either through photographs or reports, how the condition that the remains were found in?
Yes, I mean, they exhibited decomposition and had been dismembered or cut.
What about how the remains were stored?
There were plastic bags there. For example, with the skull, there was a plastic bag nearby, but the skull was in the roadway. And then the extremities were located in plastic bags. One set of remains, my understanding, was outside of a plastic bag.
Okay. And turning your attention back to the skull, and that's Exhibit 16, can you tell the jury, was there any sign of insect activity on the skull itself?
Not that I saw in any of the photographs or that I saw described.
Okay. Republished in States Exhibit 16. And what does that tell you, the absence of insect activity, maggots, fly larvae on the skull of Melissa Wolfenbarger?
Given the condition of the skull, that it was somehow protected from insects getting to it, flies getting to it. So understanding that there was a plastic bag nearby, most likely it had been in that plastic bag soon before it wound up in the roadway, because otherwise flies would have been attracted to it.
Okay. So if this skull had been out for a day or a full day, you would expect to find insect activity?
Yes, I would expect flies to have gotten to it and have laid eggs on it.
What is the impact of it being, say, double tied in a plastic bag? What is that impact on that?
Well, again, I don't know about double tied, but at least somehow being protected from insects getting to it. That would keep flies from being able to get to the remains and deposit eggs, and which then turn into maggots.
Okay. And does the storing of the remains in a sealed compartment like a plastic bag, does that impact any determination on the timing of death, or does that impact that at all?
Yes, I mean, it makes it harder because of the fact that it is, well, first of all, you don't know where it's stored, and it's confined in a plastic bag, which is going to interfere with decomposition and things of that nature. So it's going to make it harder.
Okay. And was your indication that the image depicted on States Exhibit 40, an image of a leg of Melissa Wolfenbarger, was your indication that that was in a protected plastic bag as well?
It would just, again, appear to be so, because, again, we don't see any insect activity exhibited by this leg. So I would say that it was somewhere where it was protected from insects getting to it.
Okay. And you testified that there was some type of, something consistent with the saw on, I guess, the neck, the vertebrae that you testified to. Is that correct?
That is correct, and that's based on my observation as well as Dr. Parker's report as well. Again, looking at those surfaces, they appear to have been cut.
And were there other extremities or parts of Melissa Wolfenbarger's remains that also appeared to have the same type of saw cutting marks on them?
Yes, there were.
Okay. I'm going to show you States Exhibit 41.
While he's doing that, in the Donna Adelson case, one juror was excused because she took the call.
States Exhibit 41, this appears to be the right lower leg and foot.
When Dan Markell was shot, she took the 911 call.
And State's Exhibit 42. Is that the plastic bag or a photo of one of the bags that the remains were stored in?
Yes, this is a photograph of one of the plastic bags that was associated with the remains.
Is that the type of storage vessel that could prevent insects from getting access to the remains inside?
Yes, if it's secured.
Is that also the type of storage vessel that could make it difficult to determine a time, a PMI?
Correct.
Time of death?
Yeah, post-mortem interval, yes.
Okay. Is that something that you typically try to make an evaluation, the PMI post-mortem interval, during your autopsy evaluation?
Well, I wouldn't say specifically, but it's something we generally write down descriptions of decompositional changes that can be used to opine as to a post-mortem interval.
Okay. Would the temperature outside, say the weather conditions, would that impact it?
Yes, I mean, it depends on where the remains are. I mean, where are they stored? How are they stored? Temperature is certainly a big determining factor.
Okay. What about, you testified to this, what about insect activity?
Yes, insect activity, animal activity as well.
All right. Did you see any signs of animal activity on the remains of Melissa Wolfenbarger during your evaluation?
No, I did not see any evidence of animal activity on what I had to examine or on the photographs.
And what would you observe if you'd seen evidence of animal activity?
Okay. Typically, think about, like, say, dogs or carnivore type activity, chewing, gnawing on the bones, tearing of flesh, but especially with looking at the bones, looking at gnawing or scratching, and I did not see any of that indicated on the bones.
Okay. Show you what's been marked as State's Exhibit 43. Can you tell us what we're looking at?
That looks like some type of an article of clothing, maybe a sock. I don't know. It looks kind of muddy.
Okay. And State's Exhibit 46. What is that?
State's Exhibit 46 is the left foot, again showing decompositional changes and protruding out of the soft tissue. I see a segment of bone that's broken.
Okay. State's Exhibit 47. Can you tell us what we're looking at?
State's Exhibit 47. This appears to be part of an upper extremity, so upper arm and forearm.
And State's Exhibit 48.
State's Exhibit 48, again, this looks like some type of article of clothing, maybe sweatpants that are dirty and appear to be kind of breaking down or degenerating.
Okay. I'm now showing you Exhibit 51. Can you tell us what that is?
Okay, State's Exhibit 51 are the various portions of the extremities with flesh removed from some of these bones, and they're kind of placed out on the table.
Okay. And State's Exhibit 54. You know what that is?
Okay. Yes, State's Exhibit 54 is one of the bones showing a series of kind of roughly parallel disruptions of the bone, referred to as tool marks. These appear to be superficial cuts in this bone.
All right. Now, you tell the jury, is it different cutting bone with flesh on it versus cutting a bone that's been defleshed?
Yes, there is.
And what is the distinction, or what differences in those experiences have? Can you tell the jury?
Yes, it's harder to cut through bone, specifically with the types of saws that I use when there's flesh on there, because it just doesn't cut well through soft tissue or flesh. The types of saws that I typically use, the oscillating saws, are very good cutting bone, but not soft tissue.
Okay.
And it tends to catch on the soft tissue.
And when you say tends to catch, what does that mean?
The teeth tend to be somewhat fine, and the tissue gets in there, and it just kind of snags it, and again makes it hard to control, and difficult to cut.
All right. Showing you State's Exhibit 56. Can you tell the jury what that is?
Okay, State's Exhibit 56. We're looking at bones from a lower leg. The thin bone that's at the bottom of the screen is the fibula, which is the thin bone that's in the lower leg area. And you can see the superficial cuts on it. And then the bone above it that looks more irregular, that's the tibia, and it is more broken than cut.
And you say superficial cuts.
Whoops.
Are you referring to that portion in the screen depicted now?
Yes, I believe that was in the previous exhibit.
Okay. And State's Exhibit 60. Is that further example or signs of some type of mechanical device coming in contact with the bone of Melissa Wolfenbarger?
Yes, it is. That's an end of a bone that has been cut.
Okay. All right. Now, Dr. Terry, based on your review of the photographs and reports, are you able to make an independent determination as to the cause of death of Melissa Wolfenbarger?
Yes, I can.
And what was the cause of death of Melissa Wolfenbarger?
The cause of death is ruled by Dr. Parker, or my opinion?
Your opinion.
Okay, which I think are kind of subtly different. But my opinion is that the cause of death is undetermined due to dismemberment with concealment of the remains and decomposition. And actually, and also with incomplete recovery of the remains because the torso was not recovered.
All right. What can't you determine based off the things that are missing, the remains that are missing of Ms. Wolfenbarger?
I'm sorry, can you ask me that one more time?
Different way. Did you have enough? Let me ask you this: were you able to tell if Melissa Wolfenbarger was strangled?
No.
Why not?
Because of the decomposition of the remains and the lack of neck structures to examine. That makes determination of whether or not strangulation has occurred very difficult, if not impossible.
Okay. And can you determine whether or not Melissa Wolfenbarger was stabbed to death?
No, cannot.
Why not?
Again, we're missing the torso. Someone could have been stabbed or had other injuries inflicted on the torso that would have been responsible for the death, but you don't know because you don't have that part of the body to examine.
Is that the same difficulty you would have to trying to determine if she was shot?
Absolutely, yes.
And is that ultimately why you're saying undetermined?
Yes, because the cause of death is undetermined here because can't say precisely how she died, and it is confounded by the fact that you have incomplete recovery of the remains. They've also been dismembered. There's been concealment of the remains, and there's decomposition.
Okay. Now, what would you say as to the likely cause of Melissa Wolfenbarger's death?
Objection. Speculation.
She's an expert. I'm sorry.
You want to approach for a moment?
Sure.
Now that you've just said that you cannot determine what her cause of death is, would you like to just make a stab at it? Oh, that's a bad analogy. Just a shot in the dark. Nope, that also doesn't work. What do you think? What do you think the cause was? Now that you said there was no way to tell. Oh man, this is wild. Just make a wild guess. I believe you can't say murder. I believe you can say we believe, although the exact manner, cause of death is undetermined, the manner of death would be homicide, right? Because you can infer that from dismemberment and the hiding the corpse. But I mean, this is how is this question any different from if I had done it? I would have. I just don't think we can put much weight into this. I would say that everything you had has no evidence, right? The head, the arms, the legs do not have bullet holes, stab wounds. There's nothing you can tell from that caused the death. So educated guess, the part you don't have has the evidence.
Fawcetti, if you'll rephrase, please.
Yes. Dr. Terry, is it likely that Melissa Wolfenbarger died of natural causes?
Given the circumstances, I would say that's very unlikely that she died of natural causes.
And if you could articulate why your determination is unlikely that she died of natural causes.
Again, the body's dismembered. There's an attempt to conceal by placing it in plastic bags. I don't have, she was, as far as I know, she was a young female. I have no information about any significant health conditions, but even so, the fact that she's dismembered and concealed is very suspicious for some sort of non-natural death.
Okay. And when you say suspicious for some type of non-natural death, could you be more specific? Are you referring to a homicide?
Yes, I'm saying that it's very suspicious for homicidal violence, okay, given that she's dismembered, concealed. That is very suspicious. I can't say exactly how, but it is very suspicious.
All right. And the marks, the cuts, do you have a determination as to whether they're ante or post-mortem?
Yes, I'd have an opinion that it's most likely post-mortem.
And why is that?
Well, first of all, we don't see any discoloration of flesh associated with that. Second of all, just in terms of practically speaking, it would be very hard to dismember somebody while they're alive, and especially with the marks that tightly aggregated. You'd need to have somebody incapacitated or very significantly restrained to do that. And again, this is most consistent with something that has occurred post-mortem or after death.
All right. Now, in terms of the manner in which a homicide could have occurred, if say, for instance, Melissa Wolfenbarger was strangled, would you expect to see, like I said, the presence of blood in and around the surrounding remains themselves?
No, would not.
Why is that?
Strangulation typically does not result in the liberation of blood.
Okay, and considering that possible manner of death, as well as the fact that,
I'm sorry, you said manner of death, that's a cause of death when we talk about strangulation. I'm sorry, just want to be precise about that.
Let me ask you this. Did you, when you were doing your evaluation, did you consider the possibility that she was murdered at that location where remains were located?
I mean, that's a consideration, but I don't think it's a particularly good or valid one.
Okay. So your I guess your consideration during the autopsy was that the remains may have been placed there. She may have been murdered somewhere else.
Yes, if she were murdered, it was most likely somewhere else.
That's because the remains were hidden. Indicates it was probably taken somewhere.
Just referencing things that could impact a timing of death or make that determination. Would you have been able to tell if the remains had been, say, refrigerated?
Not necessarily, no. I mean, but again, she's been dismembered and she's in plastic bags. The remains could have been anywhere.
And if it had been, say, the remains were refrigerated, how would that have impacted a time of death determination?
That would slow down decomposition, much like if you take any meat and put it in your refrigerator. The refrigerator versus the freezer, it will slow how it degrades.
Okay. One moment, Judge.
Sure.
Think we might be done with direct, maybe on to cross. See if we can finish this witness completely today. It is 4:45, but it's been a short day. Mrs. R.A. is still reading in the other room. Could the skull injury have been a fatal injury? The hit by the car? I believe they indicate that happened post-mortem. So the dog dragged the skull and the bag out into the street, and then the car hit the skull.
Your Honor, can I approach?
Sure.
I like this witness. She's completely relaxed in another world, thinking about something. I'd be a mess, shaking and nervous on the stand. And she's just like, doo-doo-doo. Just another day, another case.
Okay, thank you.
All rise for the jury.
We're kicking the jury out, but I don't know why. I'm not sure. It seems early for a break because we just had one. We came back less than we've been going for less than an hour. There was an objection. They did approach. So is there an issue that needs to be sorted out?
Doctor, if you would step outside for just a few minutes.
Yep.
Thank you.
Dr. Terry gets to wait in the hall.
Okay. So the reason that I asked the jury to step out is that we had, at one point, Mr. McDermott had objected to what he was concerned was going to be a line of questioning by the state regarding this witness's statement as to the results of some sort of DNA. I indicated that for now we were going to stay away from that topic with this witness based on the discussions that we had at the bench. And the reason that we are now revisiting that issue is that Mr. Fawcett approached and asked the court to sort of revisit that ruling, and I felt like we needed to have a more fulsome conversation on the record on that topic so that I could rule. And so that's what we're doing now. Mr. McDermott, you were the one who originally asserted that it would be improper for the expert to for Dr. Terry to make those statements, and you were citing the Williams case, which I found. I think you also cited a Watkins case, which I was not able to locate. I mean, I found, that doesn't mean it, I mean, I just can't find it. I found Disharoon, which obviously where I think Namias is indicating that's an issue that's before the Supreme Court, but.
You said Williams, but the case I cited was Smith v. Arizona.
I apologize. I thought you said the Williams case out of the U.S. Supreme Court and the Watkins case out of the Georgia Supreme Court.
Smith v. Arizona out of the U.S. Supreme Court.
That's after Williams and explains Williams.
Thank you. That's the part that shows why I couldn't find the Watkins case.
5th Arizona 602 US 799.
602 US 799. And what is the
779?
And what is the Georgia case?
Is Watkins is 320 Georgia 862.
320 Georgia
862.
Thank you, sir. If you'll give me just a second to pull that up, and then Mr. Fawcett, I was going to call on you to let me know what the state's position is.
If you read Watkins, you can start at 872, paragraph head note 16. The middle of that paragraph explains it in 2 sentences.
Defense.
Yeah,
Defense says right here. This is the part we want you to read. Judge will probably look at more than that, the context and everything else.
So, can you give me that side again? Because I thought you said 320 Georgia 860, but that's not
862.
Thank you.
Judge does a quick legal search. 320 Georgia 862. Okay, there it is. Yeah. Seems pretty clear. Think it over. So the argument is over DNA evidence with the medical examiner, and the judge had ruled previously they weren't going to go there. But Mr. Fawcett said, I'd like you to revisit that. Defense says no. Still. Do I have Westlaw? No. I don't pay for any of the legal search tools. I just have some of the best mods in the country, in the world, that can find documents for me. That's what we do. And I've got Matthias over there in Germany who can look up law.
Yes. Your Honor, the state is relying on 24-7703. I think the issue comes down to whether or not the state is intending on introducing documents related to those test results. The experts can rely on evidence, information that is not admitted into evidence, even evidence.
And routinely do, informing their opinions.
That's correct. And so her opinion is based on it's going to be called to determine the cause of death of Ms. Wolfenbarger. And ultimately, she relied on the test results from LabCorp to make that determination as to the cause of death. And that's what her opinion is based on here.
I think maybe part of the reason I'm confused is what exactly is the DNA result that we're talking about here?
So
is it confirming that this is Melissa Wolfenbarger or that there's some sort of DNA match to her?
Yes, confirm. Well, the DNA match from well, actually, no, it's the swabbing of Norma Patton and the comparison of that to the extremities that were located on June 1999. Confirming that she was related to Norma Patton. Okay, and
Is that in dispute?
I didn't think it was.
I mean, forgive me if I fully acknowledge I might be missing something here, but I was not aware that there was a dispute that those body parts were in fact Melissa Wolfenbarger's. Maybe there is.
Well, first of all, it shouldn't matter whether there's a dispute or not. The rule's the rule. They can't testify to those.
Well, except that I don't have to venture into deciding what the rule is and how it applies in this case if it's not relevant evidence. That's why I'm asking the question. But yes.
There are test results in the back and forth discussion over identifying those remains that in some cases they did not match. So I don't think it is a 100% proven conclusion that all of those remains pertain to Melissa Wolfenbarger.
Okay. Well, I guess that demonstrates that I did miss something. There apparently is a dispute that all of those body parts belong to Melissa Wolfenbarger. And again, asking the obvious, Mr. Fawcett, Why would whether those body parts belong to Melissa Wolfenbarger or not be evidence of the fact that her manner of death was homicide?
I guess I'm not understanding the question.
So I don't understand the DA to be offering, I guess the evidence that you're seeking to offer that this witness would testify about is the fact that she understood from the DNA result that those were Melissa Wolfenbarger's body parts.
Correct, yes.
Some of them anyway, according to Mr. McDermott's characterization of whatever that shows. Why does that contribute to the ME's understanding of whether the death was accidental, homicidal, suicidal, or undetermined?
Well, I mean, I think she wouldn't be performing a cause of death determination if the remains weren't first determined to belong to the same person that the skull did. And I think the skull is being compared with extremities, and that's a part of that too, because you have the same type of cuts and marks on the bones of the skull as you do for the extremities. I think that's a pretty significant fact in that determination as a cause of death being highly likely of being homicide. So I think that, it wouldn't have been a comparison of the extremities with the skull if there hadn't been that information provided by LabCorp to Dr. Terry and Dr. Parker. And ultimately, that's why they made that cause of death determination after all the parts were identified and matched the parts on April 1999, the parts on June 1999. So ultimately, if there's an issue as to a specific part, Dr. Terry can testify as to which part she swabbed and sent off. So if there's a femur versus another femur or an arm that is in dispute, I think that goes to the weight, not admissibility.
Mr. McDermott, can you, I've got Watkins pulled up, and I'm still admittedly struggling to locate the portion that you're directing me to.
Okay.
One part of the case that we were successful in.
Yeah.
Congratulations. I'd love to read it, but I can't find it.
So, first of all, that's a state case. There's also the Supreme Court case that it's Watkins is citing. But if you go to 872.
You said, I think you directed me to a head note, and I can navigate it more quickly from there.
So head note 16.
Thank you, sir.
And that'll take you to a paragraph that begins with the word second. Second, the trial court clearly and obviously erred.
I have found it now. Thank you very much.
The beginning of that paragraph says to begin the Sixth Amendment's confrontation clause.
Come on, you might as well just read the whole thing to us. It's only 2 sentences, right? This is pretty wild. I think this is going to go on the counter. We're going to add this to the counter. Up to 33 we go. Anything goes. I've got a prank call. Hang on. Hello? Hello?
Hello? Hi, this is Mary from Med Health Center.
Mary!
I'm calling to let you know that after this recent open enrollment...
Sorry, Mary. I need real people. Put your boss on the line or we can't talk. Yeah, Teresa. I wouldn't put it past them.
Ready? I'd like to add something from Smith v. Arizona that addresses their argument.
That's what I'm looking at now.
Well, Smith addresses Rule 703 and its relation to this analysis. If you go, well, it's in Section 2 under Head Note 9, but you got to go down to the next paragraph.
Mr. Fossett, have you had a chance to look at the Watkins case or the Arizona case that Mr. McDermott is referring to?
I'm still looking at it, Judge, but we can proceed.
Okay.
You lose.
As I said, when we were at sidebar, Mr. McDermott mentioned the Watkins case, but I couldn't locate it while we were up here. I have now had an opportunity to review it, and it does appear that the Watkins case and the Smith versus Arizona case on which it relies would prohibit that witness from testifying. I understand your effort to distinguish it by saying, well, we're not offering the lab result itself in evidence. And I agree with you that expert witnesses do routinely rely on other people's opinions. But I think that the original ruling I made at sidebar is still the ruling, which is that the DNA test result is hearsay. And there's no one here who can testify to its to the truth of that result, or at least, well, I take that back. There might be, but this witness is not that person.
The judge doesn't declare mistrial unless a motion's made for it.
All right, Your Honor, I would ask for permission to inquire to Dr. Terry whether she collected a sample from Norma Patton, what she did with that sample, and then what she did after the sample returned. I don't think that line of questioning, it touches on the results themselves. It just explains her actions and activity, and then what she did after she received information back from that.
Mr. McDermott?
I think the rule covers that type of questioning. I mean, it's clearly designed to elicit through dancing around the issue of the statement the truth of the statement that's in the lab results. And I would say that's just as much a confrontation issue.
Okay. So as I understand it, Dr. Terry did in fact conduct a swab herself. She's certainly allowed to testify about something she undertook. She's also allowed to say that she sent it off for testing because that's something she also did. The extent to which she received a result or anything like that, I agree, invites this sort of cutesy half dodge around the fact that there's not a DNA test result witness currently and that DNA test result's not in evidence. And so just in generally speaking, Mr. Fawcett, the two questions you mentioned at first, I totally agree those are fair game. Those are actions that this person took and she can testify about them. I think to some extent you could probably ask her what her other steps taken were in her investigation that led to her decision. But what you're going to want to be real cautious about is treading too closely to the line that invites her to say, after doing that, did you develop an understanding or whatever? Because Mr. McDermott's concern is correct that it comes too close to creating an inference that's not supported by any evidence in the trial that there was a positive DNA match.
Yes, sir. I understand.
Mr. McDermott, you can object when he asks the question if you have an objection to the particular question.
You know this is going to be a defense closing.
If you find it objectionable in some manner, other than the record that you've already made. Anything else before we have the jury back in?
The defense is going to get up there and say, they don't even know if they have the right body parts. You haven't heard anything that even says that these body parts match the same person. Oh, my goodness. Judge says, I agree with the defense on this one. The DNA report is hearsay because you don't have anyone who brought this testimony in. There may be somebody who could bring the testimony in with the DNA report, but we haven't heard it in this trial. So, I mean, yes, they do know that it's all the same person, but they haven't submitted that. They haven't submitted evidence that the jury can hear on that. So the jury does not know it's all the same person, which means the defense can argue that they haven't even proven it's the same person. This is wild. No, defense has never asked for a mistrial that I'm aware of.
Okay. Mr. McDermott, anything from the defense before I have the jury back?
No, Your Honor.
Okay. Can I have the witness back, please?
Yeah, let's grab a witness. We need one of them. This is crazy. Apparently there were 2 dismembered and bagged body parts cases at the same time in Georgia, or around the same time.
We'll have the jury back in. Thank you.
They stripped the flesh before taking a test. Can't they take a test from bone? I should know this. Can't you get DNA from bones? I mean, that's how Jurassic Park did it, right? Or, oh no, that was a mosquito. Never mind. I take that back. Back door. Somebody's here. Maybe it's my package. Jury's coming in now. Prosecution is...
Please be seated. Mr. Fossett, you may resume your examination.
See how he dances around this one.
Now, Dr. Terry, did you ever meet with Norma Patton?
Yes, I did.
And you recall around what time period that would have been?
I think it was March 19 of 2003.
Okay. And are you familiar with the process of collecting swabs or samples from individuals?
Yes.
And can you tell the jury whether or not you did that at the time you met with Ms. Patton?
Yes, I did.
And are you familiar with collecting samples from other items that you intend to have compared?
Yes.
And did you do that in this case?
Yes.
All right. And in particular, did you swab the extremities of Melissa Wolfenbarger that were located in this case?
No, the extremities were not swabbed.
Okay. What other item, a piece or body part was compared?
I'd actually have to check the record to see, but tissue from the extremities, bone or soft tissue, had been submitted for DNA.
Okay. All right. And is that the process that you use in your identifications for skulls as well as other parts as well?
It can be. Oftentimes with skulls, though, if we have dental, we will use dental to establish an identification rather than DNA.
Okay. I want to turn your attention back to some of the marks and the cutting that we were just testifying to. I'm going to show you State's Exhibit 66. Does that look like a saw to you?
Yes, that is a type of saw.
Okay. Are you familiar with the term, say, sawzall, or you with that term?
Yes, sawzall or reciprocating saw.
Okay. You familiar with the motion that type of saw makes?
Yes, I am.
Have you ever used one?
Yes, I have.
And the marks that you were testifying to in the bones of Melissa Wolfenbarger, is this the type of instrument that can make the type of cutting marks that you were testifying to?
It could make that type of mark, yes.
Based on your experience?
Yes, based on my experience.
She's used a sawzall on people? Based on her experience?
That's all I have, Judge.
Thank you. Mr. McDermott, questions for this witness?
Yes, ma'am.
It's a saws all, like it saws everything.
Hello, Dr. Terry.
Hello.
You remember me?
Yes, I did.
We met just a couple of weeks ago, I believe it was. Or
yes, we did.
Okay. And that was at your office.
That is correct.
We discussed several aspects about the case.
Yes, we did.
Okay. What methods, again, did you use to determine the identity of the skull?
The method that was used to determine the identity of the skull was dental.
And did you mention that you did x-rays?
Yes, x-rays were taken, or I had taken x-rays taken in the medical examiner's office.
Okay.
And that was to establish the dental.
And when you establish the identity through methods such as that, is it important to keep records?
Yes, it is.
Okay. And do you normally keep records when you do something like that?
Yes, records are kept in the medical examiner's office.
And did you preserve the x-rays in this case?
The x-rays should be preserved at the medical examiner's office, the Fulton County Medical Examiner's office, yes.
And are you aware that no medical or no x-rays exist in this case currently?
I'm not aware of that, but there have been changes in the regimes over the years, and at that point in time, there was the hard copy x-rays, and we kept those x-rays there. Now, I have not worked in that office since 2004, so I don't know, but they were there at the time I left the office. And now so many things are digital, but those x-rays were there at the time I left the office.
Whose responsibility was it to preserve the x-rays?
It's, like I said, they're there in the office. They were maintained in the office, so I would imagine it'd be the records.
Not the x-rays, but the charts. Do you remember the x-rays that were given to you? If well,
I think you can hear me right now.
Do you remember observing the remains of the head? You said the first time you saw it was when?
February of 2000.
Okay.
When I was turning them over to have a reconstruction done.
So you never saw it when it was not a skull?
That is correct. I just saw pictures.
Okay, so you've only seen pictures.
Up until that point, yes.
And in those pictures, you could tell that it's badly decomposed?
Yes.
And you mentioned that there were no flies on it, so that was probably a recent...
Right, that it had recently been exposed. I didn't see any fly eggs. I didn't see any fly eggs described on it. I did not see any maggots or maggots described as being associated with these remains, even though they were described as being badly decomposed.
Okay. And you remember that the other remains are in similar condition?
That is correct.
And they had been in these bags?
Correct, with the exception of the one that was out at the time of the discovery, but a bag was nearby.
And Mr. Fawcett discussed with you the concept of PMI, post-mortem interval, is that correct?
Correct, that is what PMI stands for.
And that's a fancy medical examiner way of saying how long ago did this die?
Correct.
Okay. Do you remember me asking you questions about PMI when we met?
I do.
And do you remember me asking you, based on the pictures of the skull and the remains that we saw, if that could have happened in a relatively short time?
I do remember you asking that, yes.
Okay. And do you remember answering yes?
Yes, that is a possibility, yes.
Okay. Do you remember me asking you specifically, would it have been conceivable to have gotten in that condition within 30 days?
I do remember you asking that, yes.
And your answer was yeah?
Yes, that's possible, yes.
Well, you didn't say just that's possible.
Oh, okay, well.
You said enthusiastically, yeah.
Well, I mean, again, it's possible. I wasn't having the conversation transcribed, you were recording it, but yes, it is possible.
Okay.
But there are a lot of variability or variables that go into how quickly something decomposes.
Okay. And we discussed those when we met, right? That they were in bags,
Yes, we did.
Those bags could have been exposed to sunlight.
Yes, the temperature, yes.
Temperature is very important to decomposition.
It is very important to do.
And something in a black plastic bag in the sun would be warmer inside the bag than outside.
That is correct.
Okay.
I think I also mentioned we don't know where the plastic bags have been, too. They could be stored somewhere.
It's fair to say, I'm sorry, did I stop your answer?
Oh, no, I was just going to say there's just so many variables, it's difficult to say.
Yeah, that's my point to ask. When you normally do postmortem interval on remains that are found, it's usually an intact person.
That is correct.
And all those variables you can calculate to some accuracy how long it's been.
Yes, some of those, we can, we have some knowledge of, yes.
But when a body has been dismembered, as in this case,
dismembered, placed in plastic bags, potentially concealed.
Pretty much all that calculation goes out the window.
Correct. There are just too many variables there to say what the postmortem interval is.
And I think you said to me, so it's like, could you say it's been days or weeks? Probably something like that.
Correct.
Okay.
It could be days, weeks, months. Yes.
Thanks. All the questions I have, Your Honor.
Thank you, Mr. Fawcett. Any additional questions for this witness?
Now, you were talking about the different variables. Can you say, based off of the information you have, the photographs and the circumstances, that the remains were found when Melissa Wolfenbarger died? Can you say that?
I'm sorry, can I say?
Can you estimate a time of death?
Oh, no, I cannot estimate a time of death, no.
Right. And in terms of the variables that you were speaking with, would say the tying up of the remains in a bag and dropping them off at that location, can you say that they weren't there or that she didn't die in December, for instance, of 98? Can you say that?
No, I cannot.
And what type of variables prevent you from making that determination?
Again, she's been dismembered, placed in plastic bags. I don't know where these bags have been stored or for how long have they been at the location where they were when they were discovered. Just because they were discovered there doesn't mean that they've been stored there for a period of time. I don't know where they've been between the time of her death and when they're discovered. And I don't know when the time of her death actually occurred. So I don't know.
Okay, that's all I have, Judge.
Thank you, Mr. McDermott. Anything else?
Nothing further from the defense.
Thank you so much, Doctor. You may step down.
Thank you, Your Honor.
It's 5:15,
Counsel
Your Honor.
approach.
Sue, thank you very much. Appreciate your generosity. Love that you've been here for years. Makes you an OG. I appreciate that. So at the end of the trial, we discovered that the jury is not going to get any evidence as to whether or not the body matches, like all the parts fit together. They could be dealing with two different jigsaw puzzles at this point. Wow.
Knows how to whisper. And I'm including myself in that statement. Thank you, ladies and gentlemen. So it is about 5:15. We are going to adjourn for the day. I'm going to direct you a couple things, just as I have each day. One, I need you to return tomorrow morning at 10:30. Tomorrow morning again, 10:30 a.m. We will begin then. And then I will just advise you, as I have each day, that your decision in this case is supposed to be made only based on the evidence that you hear in this case, in this courtroom, and not based on anything else. And so it would not be proper for you to do any independent research. Don't drive by anywhere. Don't look anything up. Don't look anybody up. It also would not be proper for you to talk to anyone about this case or to allow anyone to talk to you about this case. And that includes amongst yourselves until I instruct you to actually begin deliberating. And then the last thing, again, in case there is media about this case, I'm just instructing you to please avoid media. Don't watch the news. That way you understand that you'll be complying with your obligation to only make your decision based on the evidence you hear in the courtroom. Thank you all again for your patience and attention to this process. I will see you tomorrow at 10:30. Have a good night.
All right, for the jury.
So, prosecution, how do you think it's going? Defense comes over, pats him on the shoulder, and says, "Thanks for that gift. Appreciate that." And he says, "What's gift?" And he says, "This whole prosecution." Just reading lips here. I don't know why they're saying that, but
okay. Jury's clear. You may be seated. Any specific issues the parties want to take up before we move on to something else? So you'll remember I sent y'all the jury charges. I did want to have, I don't plan to have a full entire charge conference right now. But given that I expect that the state will probably be wrapping up its case first thing tomorrow, and that we either will or won't hear, depending on what the defense decides to do, I think it makes sense for us to at least have a first pass. Have the parties had a chance to look at the jury charges that I sent, and any specific matters y'all want to address in terms of concerns you have? Yes, sir, Mr. Samuel.
Yes, I've looked at them.
Okay.
You want to go specific?
Any from the state? Who's going to be handling that for the state? Like, I'm sure all of you, but which one of you is going to talk about it?
We
haven't looked at them yet, Your Honor.
We haven't thought that far ahead, Your Honor. We didn't think we'd get this far.
Well, I tell you what, let me make it easier so you're not.
A couple typos.
That's why I asked you to look at them. So let me put them on the screen, and I think that will help, because it will also let you understand how they will be displayed to the jury when I do the charge. So anyway, the second charge is just a general pattern charge. It's not a pattern charge. It's just a general charge of, hey, the law is what I say it is and not what the lawyers say it is. And then beyond that, other than typographical errors, all of these are pattern charges. The only issue is
thank you.
To this evidence in this case is such that you shouldn't be given or need to be tailored further.
I can give you a list of my issues. 131.42, witness supported. I'm not sure we had that.
Yeah, so again, I exercised no editorial control over this. I simply put on here what you guys had listed. So not only have we not had that, but generally speaking, attacking a witness under 131.41 is a very specific process that sometimes may or may not have happened either. I agree with you. We certainly have not had any witness supported. I'm not even sure we've had witness attacked, except perhaps by, that one needs to be tailored, because perhaps by prior convictions.
Yeah, and then
hang on, what are your thoughts in terms of witness supported? Ms. Hilton, the conversation we were just having.
Yes, Your Honor, we agree.
I haven't heard anyone be rehabilitated in that manner.
Correct. We will withdraw 131.
Okay. And to be honest, I don't know that anybody actually asked for that one. It's one of those, they go together. And if we have witness attacked in that particular way, then I'm going to keep witness supported in that way, unless somebody agrees it shouldn't be. Mr. Samuel?
I made a note of 131.80 in case anybody was wondering what we were referring to. I was referring to the immunity of Norman Patton.
Right. You made that note in, did you have a chance to file? I know you gave them to me, and at the time you gave it to me, you said you had not yet filed the jury charge request.
I served it. No, I didn't. I don't know how to file.
Well, somebody in your office certainly does, Mr. Samuel. So
yes, someone could do it. Yeah.
Okay.
Seasoned attorney. I don't know how to file something in court.
You know what to do about 404B and all the 1.3410. I'm perplexed. I'm beginning to think you're just not going to give any 404B instruction at all because there was no similar transaction evidence in this case.
That is, I think you're beginning to suspect correctly.
Yeah.
As I was looking at it, I had always wondered, because I'd not heard what I would clearly categorize as 404B. I understand your objection and your belief that that these prior alleged, the testimony that the state has offered about prior incidents that they would characterize as abusive in support of Dr. James or Ms. James's testimony. I believe, as I said at sidebar and then said again when I declined to give a limiting instruction, I believe that those are intrinsic, and that intrinsic evidence is allowable. The jury can consider it for any purpose, and so there's no basis for a limiting instruction.
Right. To be candid, I can't even figure out what the limiting instruction would be, which is kind of my whole issue, is what was it? Unless we accept your position that it's just all part of the crime, I'm not sure what the 404B instruction would even be, which is why I thought the evidence should be excluded. But we know where we've been on that.
Sure, yeah, and I think you have, I think I have, after I had that discussion with y'all at sidebar, I think I actually went in and deleted those limiting instructions and the associated other crimes, wrongs, and acts instructions.
I don't want to waive my issues, but I certainly understand that they're not appropriate if, in fact, they weren't admitted as similar transactions. Okay.
Yes, sir.
I think prior difficulties, 13420 still stays in now.
Any objection?
No objection to 13420.
It needs some editing, but
well, yeah, I mean, if there are parentheticals still in there, that means I haven't tailored them yet. But I'm not going to waste time tailoring stuff if everybody says no, we don't need it. So
right.
We go back to 13180, the immunity or leniency.
Yes.
Your Honor, they would object to that being given. While Ms. Patton did discuss the immunity she received, that was as related to her trial with Mr.
Patton.
Mr. Carl Patton. Is not anything doing with this current case. She hasn't been given immunity. She hasn't been charged with anything.
I'm with Ms. Hilton on this one.
This particular case or matter before this jury, there's no pending prosecution before this jury. There's no negotiated pleas. She wasn't a co-defendant in this case, so there's no grants of immunity or leniency or similar matters as it relates to this case. So we would object to 13180.
Mike, thanks.
Mr. Samuel?
Usually I do charges sitting down, but I'll stand up.
That's fine. You're not bothering me.
Once you're given immunity, you're given immunity. It carries forward. You know, all the federal cases and all of which are, the names of which are escape me now, but the New York case. Anyways, the U.S. Supreme Court said once you're granted immunity, it's good for life on that grant of immunity. So theoretically, which is all that really matters for this, she could still be prosecuted, and because the statute of limitations hasn't run, because it never does in a murder case, she could be prosecuted in theory in whatever it is, Henry County, Fayette County, wherever. And so having testified here, because she was immunized, she doesn't have to worry about that. If she hadn't been immunized, and she got on the stand here today, yesterday, whatever day it was, and said, yes, I participated in the murder of some of the people my husband killed, she could be prosecuted for it. But she can't because she's immunized.
So my concern is not quite, I think right now I sort of agree with Mr. Samuel, but not for the reason that he's outlining. It's more that my understanding of the law around it, and the pattern charge certainly, is that it's not specific, right? It doesn't say they were granted immunity in this case. And so if it's intended to be, I mean, because the factors we take into consideration when we're assessing the credibility of a witness are pretty broad. These are just examples that we give a jury in terms of things they can consider. If the state wants me to think about not giving that charge based on Mr. Samuel's request that I give it, I would say see if there's case law that talks about it being specifically designed for immunity in a case, as you outlined correctly, Ms. Hilton, that Ms. Patton was never in any jeopardy associated with this case, and I'll consider that tomorrow.
The
Okay.
case is Murphy versus Waterfront Commission of New York Harbor, 378 U.S. 52.
Ricky, thank you very much.
378 U.S. 52.
Yeah, and there's a long discussion of it in a Supreme Court case decided 6 weeks ago, Coleman versus the state.
K or C?
With a C. S25 AO191.
Did he
Different
just say
circumstances, but it talks about how broad immunity really is.
the Supreme Court decided
Once
6
you've been
weeks
given
ago?
it,
That's fresh
you're
law.
protected for life in every court for that testimony.
Okay. And as I said, that may go directly to my point that this pattern charge is not specific about this case. It's just about immunity generally, and if that's the case, then I will give it based on your request, but I would like some more information about that topic. So I'll take a look at this case and hear from the state tomorrow on that issue.
Your Honor, before you go, I'd just like to cite a case from Georgia, Lee versus State, 281 GA 776. And I believe the proposition is that the general credibility instruction adequately covers that.
Adequately covers the other immunity?
The other instruction.
Okay.
I need to drill down on it exactly,
Sure.
but that's what it's saying in the notes on the jury charges.
Okay.
So I'm going to look at it as well. I just wanted to give that to the court.
Thank you. I appreciate that, Mr. Wilson. Okay. Anything else, Mr. Samuel?
Yeah, a few more, but they're not big. 13430. It really just needs to get rid of all the parentheses for the defendant. No felonies of Mr. Wolfenbarger's work, but all the witnesses.
Yeah, that's why I haven't tailored it, because
At first I crossed it out, but then I realized, wait a second.
Yeah, there's lots of witnesses we've heard felony convictions about. And so if evidence comes in about felony convictions of the defendant, right, then I'm not saying it has, I'm saying if it does, then I would tailor it to be, you've heard evidence about both the defendant and a witness's criminal history. But if it's just witnesses, I'll say that.
Right. I'm a little in doubt about 13510 identification. The first page of it, I think, is fine. You got to prove that the defendant did it. That have identified him as being, but this is all about whether you can trust eyewitness identification, et cetera. Which we really didn't. I mean, it's not an issue in this case. We don't have any eyewitnesses identifying anything. So I just thought we should get rid of that and 13511. Those two pages, but leave the first one, because that just says someone's got to identify the defendant as the perpetrator. It doesn't necessarily have to be in court, but
I believe we may agree, but if I could just have a moment.
Sure.
Tonight to.
That's fine.
We may be in agreement about that.
Okay, let me know. Like I said, I think to Mr. Samuel's point that second part, the some but not all of the factors, if you read those factors, they really do go to a stranger's identification based on eyewitness observation, and that's not really what this case is about. I'm not sure I necessarily agree with your assessment of 13511, that would be more directly here in terms of the state's obligation to identify a defendant, but we'll go, I'll let the state have a chance to look at that and consider it and tell me tomorrow.
I crossed out my crossing out.
Okay.
That was him still in.
Okay. Anything else, Mr. Samuel?
Got 2 or 3 more. Sure. I'm not sure about the motive instruction. I think they have to have evidence introduced of the motive. I know motive is in the malice murder instruction already. That motive is not an element, but may help you decide. But I don't feel strongly. I know it's a pattern instruction. I just don't know that there's evidence of motive that's been introduced exactly. It seems like.
Except that the pattern says they don't have to prove motive to prove murder, and it also says any evidence of motive. If you want to argue there isn't any evidence of motive that's been offered, you can argue that, and they'll say, but yes, there has been. It doesn't matter. As I understand it, that one is written broadly enough that both sides can argue, here's our evidence of motive, even though we don't have to give it to you. And you can argue there isn't any.
There was I got a typo in causation in felony murder 21030.
Yes, sir.
But 220.23.1, which was ours, I'm not quite sure what to do about that.
I'm sorry, what is the typo?
2.20.23.1.
No, I'm sorry. What was the typo in the causation charge?
It says felony murder if you believe that they instead of he.
Thank you.
Yep. 2.20.23.1.
The state should rest tomorrow morning.
I just don't know how we're going to address this, but we need to probably think about it. Everybody needs to think about how we're going to talk about the aggravated assault that makes it aggravated.
full disclosure, when I was drafting these charges, realized that I've tried a number of felony murder cases. I've actually not tried a felony murder case before this one where the underlying felony wasn't also charged. I don't know, as my understanding is, it's not required to be, but I've just not had one where it wasn't also charged.
Well, they actually didn't even request ag assault in their pattern.
I understand.
Which Joel and I spent a lot of time thinking about why they didn't do that. But at any rate, we did.
They're like,
but now
we
the question
didn't?
is, how do you do it?
What?
Well, I think we all obviously need to have a more detailed conversation about it tomorrow after everybody's had a chance to look at it. But the
state screwed up again.
Aggravated assault charge I think is less confusing. The issue is deadly or offensive. I don't think that I can meaningfully charge the jury on felony murder if I don't tell them, but the felony is based on an underlying alleged aggravated assault. So I think I have to tell the jury, as felony murder says, the underlying felony that's alleged is whatever, and I will define it for you shortly. So I have to tell them what aggravated assault means, but that typically requires the court to explain what type of weapon did it, because that's one of the elements, is that you assaulted another person with an offensive weapon, and then you have to explain what was offensive about it.
Murder, felony murder.
He's like, the murder was offensive. I'm counting this one, 36.
Just to anticipate what we may be talking about tomorrow, it can't be strangulation because that's a separate crime, which is not alleged.
Is the aggravated assault
It's only offensive weapon, not
charged as an offensive weapon in the indictment?
Yes.
Okay.
Look at the body language of prosecution. Oh my goodness. They somehow managed to limp to the finish line only to be shooting themselves in the foot.
Okay. Anything else?
It's not in there. You can look anywhere you want. It's not there.
Nothing. That's all I had on my list.
Okay. I'll just note, in case y'all didn't, it sounds like you would have looked at it, but I do another one that is non-pattern that I typically include. I cannot believe there's not a pattern on multi-count indictments. But this is the one that a lot of us use, and so I include it. You'll also probably note that my charge is sort of in the order of, this is how you consider evidence, and this is, what's been presented to you and how you should think about it. Here are the elements of the crime that you're supposed to be determining if you believe occurred, and then here's how you deliberate. That's sort of the way it's broken up, and so you'll note it's not in number order, but that's sort of how I present it. And also, I sent y'all a verdict form the other day. It's pretty straightforward. It just says we find the defendant guilty or not guilty on count 1, guilty or not guilty on count 2. Any objections to that verdict form?
Sounds great.
None from the state.
Nothing from the defense.
Okay. So I think it sounds like what I'll do is I will tailor some of the ones that it seems like we're in agreement are going to stay in based on the evidence as it currently exists. Obviously, they can be tailored again, depending on, I sometimes will tailor the defendant's choice not to testify, depending on whether he testifies or not. Although I think the pattern is written generically enough that it can stay in either way. And then obviously, depending on any additional evidence that comes in regarding criminal history, I can tailor those. Beyond that, what I'll do is wait until tomorrow, specifically so we can talk about the aggravated assault and offensive weapon charge, what we're going to do with that, and then the other ones, the other few that we've discussed.
If there is a directed verdict or a judgment of acquittal, that'll be tomorrow.
I'm sorry. Can you ask us about tomorrow's schedule? It's 10:30 because you have something else we need to clean up. Do you have another calendar?
Yes, I have the presiding bond calendar tomorrow morning.
So we need to clear out.
Yes, sir.
Okay.
I'm sorry.
We'll put everything in the back. And assuming our case takes a couple hours, I don't know if they have rebuttal. Do you envision going into closing argument tomorrow, or waiting until Friday morning for that?
If what were to happen is that the state were to stand up and rest in the morning, and then you put on a case that is relatively straightforward and short, even assuming rebuttal, the state, we probably would be done still in the afternoon. I'm saying pushing 3 o'clock is my guess, at which point I'd rather get a final on the charge and start fresh on Friday morning we all agree that we've got the charge final, and so you guys get ready to do your closing, and then I think that time would be better spent tomorrow afternoon. So no, there's a very long way of answering your question, Mr. Samuel. No, I do not expect to go into closing arguments tomorrow afternoon. Anything else?
No, Your Honor, nothing to say.
May I have just a second, please?
Yes, sir.
Huddle on the defense side. Let's mute the mics for a second. Man, Fulton County has delivered.
One of my witnesses that we expected we may possibly be testifying today, so I had all my witnesses come.
Yes, sir.
And one of them was supposed to come and didn't come.
Okay.
And I think she's a little bit of an adverse witness.
Yes, sir.
So I'm wondering if we could make
Go get her.
arrangements possibly for tomorrow to have a deputy pick her up.
Go get her.
Is it someone, I mean, I don't have any objection to that. What are the states, are y'all aware of who this is?
Wendy Waddell.
I'm so sorry, Your Honor. We were talking about the aggravated assault.
That's okay. Mr. McDermott was saying he had a witness that was supposed to be here today who did not appear, and he thought that she might be somewhat reluctant or adverse, and he was requesting the court to see about having a deputy assist her in appearing tomorrow.
Oh. No objection from the state?
If you have an order.
I will, well, I was going to say, if I could touch base with you in the morning.
Sure.
I'll talk to her again tonight, hopefully, and we'll see where
Okay.
it's at.
The only thing I'll ask is if you do want me to do that, you need to have a proposed order ready for me to sign. I may need to change it, so you can just email it to me in Word format. But that way I have something done and you don't have to wait for me to write an order.
Okay.
So, okay.
Staff have a form order for that, or can I make one?
They probably do, but I don't have one at the ready, so.
All right.
Anything else from the defense?
Nothing from the defense.
Okay, we are adjourned until tomorrow morning.
I heard Wendy
at 10:30.
Wendy Waddell or something like that was the name of the witness. As we adjourn for the day. So defense has witnesses. He said we anticipated starting them starting testimony today, so I had them show up today. But one witness didn't. This Wendy lady, who he anticipates is an adverse witness, meaning somebody. She is adverse to showing up to court. She did not today. Another reluctant Wendy. Yes, we get a couple of these. I won't put this on the anything goes because we've seen this in other trials as well. It's not common, and this is actually the right way to do it. So I'm not adding to the counter for that. But we're already over like 36 already. Wow. So anyway, that's we've got a runner. Tomorrow's going to be epic, I think. First of all, the state's going to rest. We might hear, I didn't hear it mentioned today, but we might hear a motion for a judgment of acquittal. I don't think that will succeed. So that should happen. Then going on to defense, it sounds like we do have some testimony, even if it's only just a couple very quick witnesses. Not sure about rebuttal. Obviously, Miss Hilton was ignored the conversation the judge was having with defense because she is still very concerned about the issue they're having with the underlying felony, which was not charged, even though it was indicted that way. That might be a bigger issue. That's one of those technicalities that might be like, and you get to do this over. This is the prosecution in Fulton County scoring a massive own goal. In the terms of soccer, with they dribbled all the way down the field, and by dribbled I mean they dribbled all over the field, dribble, every sense of the word, and then own goal at the end. This is terrible, but the judge seems to think there might be a way around it. She's like, I've got to read the law this way, but it says underlying felony, which you didn't charge, and it has to be an aggravated situation with a weapon, which you don't know, and it can't be strangulation, which is the only thing that you possibly think it could be. How does that go? That's wild. All right. They forgot to address one of the charges. It's a small thing. The bigger charge references an underlying charge which is not there, which they can't prove. It's not like they can just say, we'll just add it to charges. They can't prove it. Oops. This is like building a Lego foundation without the base. And they're like, it's okay, we'll just skip it and say as if there was something there. And you guys can just, jury can decide, you decide what aggravated weapon you think he used that got us to this point. Oh, man. Wild. Another day. Another crazy, crazy day in Fulton. All right. Play the right song. There we go. Oops, I did it again. Way to go, Brittany. All right. We've got just a couple minutes. We have to wrap up before 6 o'clock, or 6 hours. So I did notice that Phil, TYO Toys, put out a new tweet about Hump Day. I can't wait. It starts with my face on it. I can't wait to watch it. I usually just retweet whether it's flattering to me or not. But if you're on Twitter, you might want to check out @TYO Toys for some great recap of some of the great events that happened during the day. And I'm sure Waffle House is going to find its way into this one from Phil. So tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe. We'll go live again tomorrow morning. It'll be a little bit of court hopping as we get ready for this trial, the Wolfenbarger trial, which starts at 10:30. And we anticipate tomorrow the Donna Adelson trial will begin. They are so close to having a jury all picked out. I think they have to do more limiting down. They've got like 110 people or so that have made it through the first step, and it should be much quicker to whittle it down to the case, to the deliberating jurors and a couple of alternates. So we'll see how that goes. You guys have a good night. We'll see you tomorrow. Bye-bye.
I don't like podiums, Your Honor.
There's nothing in the order that restrains you from talking to cats.
Thank you.
What more do you need to see?
Have them send someone with more experience.
You don't put a diplomatic plate on a hoopty.